call for the day, Your Lordship.
Will come after 1 week only. Start talking. Any request? You are for the petitioners?
Yes, Your Lordship.
May I please, Your Lordship? Lordship, I have filed a criminal petition, Lordship, challenging the prosecution, Lordship. And the case fixed before the Garnet Court below is on 28 May.
Criminal petition, you have to make a mention again, or this time? 1-5, court number 15.
Court number 15, Lordship, from today onwards, it is taken civil matters, Lordship.
No,
Only on
that I cannot say at this stage. Court number 15 is taking civil matters from today.
Yes, roster shows that, Lordship. Roster may kindly-
Then you just clarify before the registry only, because I'm not supposed to take.
The rate-
If not 15, she is suggesting that 18. Because senior bench will be there and mention matters.
Legal Lordship. Lordship, I need to mention item number 6, 7, 8, 9, and 45 and 46. Lordship.
Wait. 6, 7,
8, 9,
6, 7, 8, 9.
45 and 46. Lordship.
45, 46. These are what? Connected matters or what?
Separate matter, Your Lordship.
Ah,
Has some personal difficulties. These are paid for adjournment of this matter.
who is your senior? No, sir?
They are Rodriguez.
Huh?
They are Rodriguez.
Or J.I. Bormia. In all the matters,
All this,
he is there.
1 week, Lordship.
Inconvenience or inconvenience. নাম্বার এটা নোট করছে। Mr. One.
All like that.
May it please, Your Lordship. Lordship, with the consent of the other side, I beg to mention item number 65 and 66. Lordship, in this matter, we are being led by Senior Counsel D.K. Mishra, sir. However, the Senior Counsel has just been released from hospital yesterday.
65 and 66.
Lordship,
Who is the counsel?
D.K. Mishra, Senior Counsel.
63 to 66 are connected.
We have taken consent, Lordship.
Not connected, but
Different council.
Mishra's name is not reflected or what?
Lordship, the previous counsel has been elevated. Previous Senior Counsel has been elevated, and so we will file a fresh wakalatnama. which will
Where
come from
the
Delhi.
advocate Mishra is there. Ground rate will liquid. You are for the 65 and 66.
65 and 66.
But 63 and 64, who are there? 63 and 64? Mr. O.P. Bhatti is there, but these are all connected, I think. These are all connected matters. If the other side, the other two matters, if they are ready, I don't know, but otherwise these are all connected.
Lordship.
Mr. Bhatti is not here now. O.P. Bhatti is there.
Will be till the town council issue, then after the council, they will.
Then what about 65, 66 we can?
Yes, it will be adjourned.
Hmm.
We'll wait for 63 and 64, somebody comes up, then we can. Yeah.
Yes, sure.
Lordship, there is an interim in the matter which may be continued.
That means since the matters are running from 2016-17
Lordship.
and interim is still working, this hearing is not continued.
Lordship.
See, if once interim is there, then this is there only. This is the fact. Interim be continued till next date of this thing.
Obliged.
Only 65, 66 correct target, yeah. Later on 63 and 64, we'll see to it afterwards. Yes, sir.
It is up to item number 33, Lordship.
Hmm.
33 of today's report.
Acha.
We have filed a written argument to it. Maybe call it on record, Lordship. Perhaps it has not come. Yesterday we have filed.
33.
33.
You have already filed.
Already filed. Yesterday we have filed.
The written argument we can call for. Okay, we are calling.
May please, Your Honor. Your Honor, I beg to mention item number 47. With the consent of the other side, I pray for adjournment for today. As Lord Venkateswara Senior Counsel, Zero Kamar is not out of station.
Chat Kamar is not there.
Out of station.
Out of station, COVID, Chat Kamar.
So,
item number 42, you have taken consent. with the
47,
other
we have taken consent. And for a petition side. So,
Yes,
Lordship,
Dr.
interim orders will continue.
Please stop for 1 week. Interim will continue. till
Lordship,
set of
2
this.
weeks become.
Huh?
Lordship, 2 weeks.
2 weeks. Okay, 2 weeks.
Interim order may continue.
They continue.
7,
47.
Please, Your Lordship, I beg to mention for listing of criminal petition number 811 of 2019 on 29 November.
You make a mention before either court number 15 or court number 18. If 15 is taking civil bench, then 18. Make a mention over there. This is a senior bench.
I beg to mention item number 43. As per the last order, Lordship, Honorable Justice Krishna Phukan Court directed to issue notice to the appellant via the registry routed through the PS. But we failed to make any communication with the appellant. So this Honorable Court may pass the same direction. Lordship.
Why the appellant was, I mean, why it was there for appellant, why notice was to issue?
Because we failed to make any contact with him. the appellant.
Acha, that was your submission. 43.
43.
So that means you have not taken steps
Yeah, the court has taken steps. I mean, they,
through registry only.
yes,
The direction was given to the registry for taking
Yes.
steps.
yes.
43. Order dated, you say?
Order dated, I'll quickly look upon it. Sure. The last order was dated 24th of 10, 2024.
2410. 24 that you are. The registry will do the needful as per in percent to the order dated. No, as per order dated 24th and 2020. List accordingly after 2 weeks. After 1 week. Not after 1 week, 2 weeks. After 2 weeks. Okay.
Material. My lord, I recommend item number 10, my lord. I am being led by Mr. Arpit Thakur, the senior advocate. My lord, can this matter be taken up at 2 p.m., my lord? It's a motion matter, my lord. There is little admin.
2 p.m.
Yes, my lord.
Okay.
He's in courtroom number 1, where is type of. Deep localized, my lord.
May it please your lordship. Lordship, I beg to mention for listing a bail application for next week, lordship, 4th of December, lordship.
4th of December.
Lordship. Oblige your lordship.
Item 1 for motion.
May it please the Lordship. Lordship for a TT bail application, Lordship. Praying for regular bail to Mr. Mohammed Nazmul Mia, Lordship. Lordship, he is behind the bar since 2/7/2022, Lordship. And
2/7.
2/7/2022. 2/7/2022. Lordship. Allegation is that Lordship under section 22C and 29 of NDPS Act, Lordship. In this case,
So
Lordship,
what is the stage of the case at present as per your
at
information?
present, Lordship, the case has been fixed for evidence, Lordship. Lordship,
Evidence.
Evidence.
In which court it is pending?
Amingao, Lordship. Additional decision session judge Amingao,
Amingao.
Lordship. So, Lordship, at this stage, kindly call for the LCR, Lordship.
They are calling.
Call for the LCR, Lordship. And Lordship, another co-accused has filed another bail application, Lordship, that has been fixed on 3/12/2024. Right, BA number 2152/2024. Co-accused, another co-accused, Lordship.
Bail application, yes.
2152.
2152 of 2024.
24, yes, Lordship. That has been fixed on 3/12/2024.
3/12/24.
Yes, Lordship.
Call for the scan copy. We are tagging with this one.
Yes, Lordship.
Scan copy list on 312 along with BA 2152 of 2024.
2152.
Yes, 2152.
Yes. Must apply.
Item 2.
May I please, Your Lordship? The criminal revision petition, my lord, against the judgment of the Honorable Session Judge was
Why I is for?
IS for Lordship. Initially, the additional seizure my lord, 6 award convicted the petitioner under section my lord 325 for 1 year and of 10,000 rupees of charges under 325. Thereafter, he approached the session judge my lord. The Honorable Session Judge modified the order This is the page number 48, ma'am. Modified the
48 of your revision.
revision petition. Oh, sorry. IA. May I read, madam?
Hmm.
Accused Pranjal Gogoi is convicted under section 324 IPC for this conviction under section 324. The accused Pranjal Gogoi is sentenced to suffer simple imprisonment for a period of 4 months and to pay a fine of rupees 2,000 in default to suffer simple imprisonment for a period of 15 days. Now the petitioner came before this honorable court, my lord. I have also filed this IA for suspension of sentencing. My lord.
Suspension of sentence. Otherwise, he is in previous bail.
Previous.
Hard MS. P. Bora. Learned counsel for the petition. Also heard Mr. BS Law Goswami, so DP Goswami, the ground on its additions. PP for the state respondent. I to liquido. This is an I, condition application under section 430 of BNSS 2023, praying for suspension oblique stay of the operation of judgment and order dated 26/9/2024, passed by Learned Session Judge Sagar in criminal appeal number 16 bracket of 2, 2023, and judgment and order dated 28/3/2023, passed by Learned Additional CGM Sagar in PRC case number 258 of 2028, convicting the accused appellant and sentenced him to undergo SI for 4 months and to pay a fine of rupees 2,000 in default SI for another period of 15 days under section 324 IPC. It is submitted by Ms. Bora that the present petitioner, accused petitioner, is in previous bail, and during the entire trial of the case, he was in bail and never jumped over any condition of the bail. And accordingly, by the present application, it is paid for suspension of sentence and allowing the present petitioner to remain on previous bail. Mr. Goswami, the learned additional PP, raised no objection in this regard, considering the term of conviction. Next paragraph. To hearing the submission made by learned counsel for both sides. The present petition is allowed. And the operation of impugn judgment and order dated 26/9/2024, passed by Learned Session Judge so and so is state public suspended till disposal of the connected revision petition. The petitioner, accused petitioner, is also allowed to remain on previous bail till disposal of the revision petition. With the above observation, I stand disposed.
Madam, notice maybe
Notice.
respondent number 2.
Respondent is there.
Respondent number 2 is also there, informant.
Main petition cannot criminal division to notices of readable. Call for the LCR. Not formal notice is required to be so and so readable. Number 1. During the course of the day, the requisite extra copy may be served and list accordingly after 4 weeks. Okay.
Obliged.
May it please your lordship. Sincere apologies, lordship. Lordship, I beg to mention item number 22, 23, and 24, lordship. With the consent of the other side, lordship, the matter may be passed over for the day, lordship.
These are all connected matters.
Yes, lordship.
Why? What is the difficulty on your part?
Lordship, the arguing counsel.
Who is the arguing counsel?
P dash, lordship.
PDAS. আচ্ছা,
So today is his marriage, lordship, so he is unable to appear. Interim is there, lordship.
with the consent committee, Mr. PDAS is not in a position to appear, so we'll stop. Interim will continue till next date of listing. List accordingly, you two need 2 weeks,
2 weeks, lordship.
list up to 2 weeks.
Lordship, a fixed date may be given.
No, sorry.
Much obliged, lordship.
I can trade.
Oh, you are appearing for the other side here?
Yes.
Okay.
May it please your lordship.
Yes.
My lord, first of all, I beg to draw your lordship attention at page 14 to 34, your lordship.
14?
14 to 34, your lordship. It's the judgment, your lordship, passed by the JMFC Morigao in CRDB case number 90/2020, your lordship. Here, your lordship, the respondent has filed an application, your lordship, under section 12 of the Domestic Violence Act, your lordship. Seeking relief under section, your lordship, 18 to 22, your lordship. Different reliefs, your lordship. And accordingly, your lordship, on receipt of the notice, your lordship, we did appear, submitted my written statement, your lordship, denying all the allegations, your lordship. This is brought by me, your lordship. And accordingly, your lordship, I have been also been examined as DW1, your lordship. And they have examined the respondent examined hospital as PW1 and his brother as PW2, your lordship. In the judgment, it has reflected that the allegations are corroborated, your lordship. But I have denied all the allegations, your lordship. That allegations were brought that I demanded, your lordship, the dowry, your lordship. But what happens is that, your lordship, I have been directed to pay in this case, your lordship, rupees 10,000 per month, your lordship. And also 50,000 as a compensation, your lordship. And also the area amount of rupees more than 4 lakhs, your lordship. So, lordship, although I am a serviceman, your lordship, I am a government employee, my salary is 50,000 rupees, your lordship. Because, your lordship, because of some serious ailments, your lordship, I have been suffering from illness, your lordship. Therefore, I have taken loan of rupees 10 lakhs, your lordship. And for that, I have been paying the EMI of rupees 20,000 per month. And your lordship, and for the expenses of my mother is also, I have been paying regularly expensing of 10,000 rupees. And also one of my elder sister, her husband already died, your lordship. And I have to look after her also. So this is the, your lordship, the situation, your lordship. I have been directed. But what happens in your lordship when the judgment is delivered to pay all this under section 18 to 22, lordship, then your lordship, I prepared an appeal, your lordship. And this appeal is prepared after 118 days after this judgment was delivered. There is a delay of 118 days, your lordship. And therefore, your lordship, I have filed a petition under section 5 of the Limitation Act for condoning the delay, your lordship. But your lordship, that has been rejected, your lordship. My humble submission before your lordship is that since I have been directed to pay, judgment is against me, your lordship, directed to pay 10,000 rupees and all other, your lordship. But the delay, this condition of petition has not been decided on merit, your lordship. At least, your lordship, appeal has been admitted, the condition has been ought to have accepted, your lordship. And the appeal, after admitting the appeal, if there is no merit in this case, your lordship, then order could be passed, your lordship. But your lordship, I have not given the chance to your lordship. In the condemnation itself, it has been rejected, your lordship. So
The
my
delay was not condemned.
the delay was not condemned, your lordship. So my humble submission, your lordship, page 37 to 43 may kindly look into. 37 to 43, your lordship. Here, your lordship, only this specific point has been raised by the, your lordship, learned court below, lordship, that I have not taken leave, your lordship. Although I have been suffering from illness and I have submitted some prescription, your lordship. But that relevant point of time, so had I been the service holder, so I could have, your lordship, the leave certificate, leave as a matter of proof, but that has not been provided. So that is the ground taken while rejecting, your lordship. So my humble submission, your lordship, this at least I have been allowed to continue the case. So to allow my,
Oh, your condonation delay is on, the condonation
Lordship.
petition is already rejected.
rejected, Your Lordship.
Yes.
37 to
And we have
42,
to
Your
take,
Lordship.
issue notice. Is there any ground and?
So,
otherwise?
so till then, Your Lordship, till then, because till then, the operation of Your Lordship, the order dated 12/3/2024 passed in CRDB case number 90/2020 till maybe state, Your Lordship.
Sorry.
Lordship.
No stay can be passed. Your appeal is not in existence, it's already been rejected. Now,
No, no,
another,
lost-
what
lost-
condition your appeal will be
No,
stayed?
Lordship,
Not at all. It's not, it's not
Lordship,
questionable.
it is in the condemnation.
No, no, no. Yes, again, the condonation, it was rejected. We have come, stay cannot be there, stay, not at all. It's not a case of stay. Not at all a case of stay. You are a government holder, pay something at least.
No, no,
A request may be there.
I have more particularly Lordship stated in my petition.
No, no,
Although
petition
I am,
will come later on. Yeah, now your petition, your condonation has been rejected. Against you, that is the appeal is there only. I mean, this revision petition is there. We cannot go by the record now. Heard Mr. A Devan, so and so. বাকি issue notice করে দিব, listen application করে দিব, issue notice করে দিব। Also called for the now এটা কৰিব। One, you call for the scan copy of the CRDB case number 90/2020 and appeal or you can call for the LCR only. Appeal number is criminal miscase. I'm sorry. Appeal is number.
Your Lordship,
criminal-
there's no appeal number. There's a miscase, Your Lordship, miscase oblique 6/2024.
No, it was in connection which appeal was numbered, not yet.
Not, because the in condemnation,
No, but in the trial court, there is a provision that numbering of criminal appeal is there. Your miscase may be separately numbered. There was no number at all. In High Court, there is a practice that until and unless the delay is condoned, the
Lordship.
number is not there. But in the trial court, that is not there.
Lordship, yes, Lordship, I have obtained all the certificate copy, Lordship, and so far the information derived to Lordship. We have obtained the criminal miscase number 6/2014. So this is the order
No,
passed.
okay then, but what is the connected criminal appeal, their number? Against, do you have filed an appeal against the order passed by the magistrate?
Yes, yes.
So what was the appeal number? It's not, no appeal number was there?
Appeal number one. So
No,
far the
it
information
cannot
that-
be, it has to be. Okay, miscase to call for you.
So Lordship, so far the direction regarding Lordship, payment of ₹10,000 monthly Lordship maintenance, I have been paying right from the very beginning, from the order, from the date of passing the judgment, Your Lordship. So that part I am complying with the order, Your Lordship. So far the area part is concerned, Your Lordship, 4,05,000 rupees. So that particular, at this moment, Your Lordship, I am some financial hardships are there because
No,
myself.
okay, we'll hear it after only. No stay, nothing. After 4 weeks.
A date may kindly be given, Your Lordship.
4 weeks of the date give us.
Date at
In the month of January.
Obviously, it will be month of January only. I
a
think.
date may kindly.
Date. Yes, and date. 7/7/01.
Oblige.
Item 4.
Same.
Yes, Your Lordship, this English petition deferred against the judgment dated 19/9/2024, passed by the Lineup Additional Session Judge in criminal appeal number 9/2018, whereby affirming the judgment dated 24/4/18, passed by the additional CGM in CR case number 67/2015, Lordship. So the case of the petitioner is that the petitioner was the licensee of the IFL shop, Lordship, and the complainant was the tenant of the IFL shop. The petitioner son gotten at the time of the license, he is an unemployed youth. After he gotten service, so he surrendered the license, Lordship. Accordingly, a settlement has been made between the petitioner and the complainant, Lordship. Accordingly, 6,60,000 rupees have been paid, Lordship. For that, Lordship, 2 check has been issued by the complainant in petitioner, Lordship. One is 2 lakhs and another is 4.6 lakhs, 60,000. 2 lakhs already encased, Lordship. On the request of the complainant, Lordship, 4,60,000 rupees already paid in case, Lordship. After that, he supposed to return the check to the petitioner, but he has not done it. And accordingly, he filed a case against the petitioner, which was registered as GR case number 1675, which was in his lawsuit, the petitioner and his firm was acquitted by the trial court. They failed to produce the original check before the trial court, and without giving any opportunity to the petitioner to produce other documents lawsuit. So I placed before lawsuit to state the impugned order lawsuit.
What kind of impugned order? No.
The judgment dated 19/9/2024, wherein lawsuit directed the petitioner to pay 4,60,000 along with a fine of rupees 25,000 in the NIA lawsuit, as by the CR case.
Now,
In the same
what is
incident,
the
there are two
order of appeal of FMD?
Defending lawsuit. In the same case, same incident, there are two cases. In the GR case, we are acquitted, where they allege that we snatched the check in question lawsuit.
Yes.
If a matter of NIA states, go to the implement.
Actually, there is a notice that issued and the impugned order
This should go also at this.
and impugned order may be state lawsuit. They may appeal also.
Without hearing the other party.
So as per the order of was there any the sentence was also, I mean imprisonment part is also there?
Imprisonment was not there, loss. Only fine loss.
Only fine.
Only fine the check amount 4,60,000 and fine is 25,000. In the GR case, they all are acquitted lawsuit, the same incident. The complainant alleged that witnessed the check. But lawsuit, if lawsuit are the judgment lawsuit,
GR case number is
1476 of 2015.
1476
2015.
by order dated which you have acquitted?
By order dated lawsuit 10/4/2018.
10/4/18. You got acquitted.
Lawsuit.
And here the NI is
NIA case is nothing, judgment is lawsuit.
additional session judge is of
24/4/2018. The CR case.
and the judgment on the criminal appeal was
Criminal
passed on
appeal was in
24.
19/9/2024.
So after long
Lawsuit.
6 years, after 6 years you have filed
No lawsuit.
appeal.
Appeal filed in the immediately lawsuit. The judgment come on 19/9/2024. The appeal.
Oh, acha.
The CR case disposed of on 24/8/18. After that, the appeal was pending and finally disposed of on 19/9/2024. In the GR case lawsuit, the FI was lost after the endorsement of the bank lawsuit. The return number on the bank was on 5/8/2015.
We are not number 4. No?
4.
Heard Mr. N.J. Gogol. Heard Mr. N.J. Gogol, Telangana counsel for the petition. And also heard Mr. D.P. Nosami, Telangana additional PP, appearing on behalf of said respondent. This is an application under section 438/442. Repeat section 528 of BNS 2023. Against the judgment and order dated 19/9/2024, passed in.
Criminal appeal number 9 of
Passed in
9
criminal appeal number 9/2 of 2018 by additional session judge FTC Sibsagar, affirming the judgment and order of sentence dated 24/04/2018, passed by learned additional CGM Sibsagar in CR and NI of 67 of 2015. Issue notice for respondent number 2. No formal notice is required to be so and so. also called for the scan copy of the LCS. Next para. Mr. Gogoi submitted further on the interim prayer that the present accused petitioner the another case was also lodged by the respondent number 2, which was registered as GR case number 1476 of 2015, wherein they already got acquittal. He already got acquittal by judgment and order dated 10/4/2018, wherein the allegation of snatching of the check in question was alleged against so and so. He further submitted that as per the terms of the agreement, he already paid the amount, how many? 4 lakhs?
60,000.
4,60,000 to the respondent number 2. However, at that time he issued a check, which is check and even after payment of the amount in question, the check amount in question, the respondent never returned the check, and with false implications, the case was filed against him. Accordingly, he submitted that till disposal of the present criminal division petition, the judgment and order dated so and so may be stayed oblique suspended. Next para, hearing the submission so and so corrected by the law, and let the judgment and order dated so and so affirming the judgment and order dated so and so be stayed oblique suspended till next date of listing. List accordingly after 4 weeks.
Highly omnis.
May I plead your lordship? Lordship, this is a criminal revision petition against the order dated 23rd/10/2024 passed by the learned Principal Judge Family Court. The brief of the case is that, lordship, respondent number 2 filed a criminal petition under section 125 of CRPC paying for maintenance. And learned court has passed an order on 15/6/2022 at the rate of 15,000 to the respondent number 2. Subsequent thereto, the respondent number 2 has filed an execution petition, stating that there is an outstanding of 8,79,000 as an area. What happened in this case, lordship? The petitioner has been paying the 50,000 amount per month to the respondent number 2 regularly, but as the judgment passed that the amount should be paid to the respondent number 2 from the date of filing. So initially he was paying rupees 8,000 as per the order dated 8/10/2018 as an interim maintenance. So there was an accumulation of 7,000 per month, and that apart, as it was ordered that it has to be filed from the date of filing. So there was an accumulation of that amount. Now, lordship, what happened in the execution case? The learned principal has passed an order directing him to pay 1/3 of the area sum of amount. That is amounting to near about 2,50,000. The petitioner's contention submission is that he is ready to pay 1 lakh as of now, and the rest amount he intends to pay as an installment. He will add more amount with that 15,000 amount, like 5,000 or else. As because what happened, lordship, recently he has undergone a kidney operation. This is the medical documents. So one catheter here has been still attached to his body, and he is directed to review after 10 days, and it has also stated, lordship, for this grounds, lordship, he is not in a position to pay the entire amount of 2,50,000. Instead, he is saying that he would pay 1 lakh, and the rest amount will be adjusted with the monthly maintenance. Otherwise, he has no any other problems, lordship. But as he has incurred a huge amount during this medication, lordship, he is not in a position. So his submission is that the honorable learned court may not take any harsh action against him, because 1/3 payment he cannot make at this stage.
And
No, otherwise, what was the area amount in fact?
it
I
was
suppose?
8,79,000 as per the respondent number 2.
So the court asked you to pay 2,50,000.
One third of that amount. That is amount here.
See, the huge, this is quite a huge amount.
Huge amount. That is admitted fact, Lordship.
How will you able to return all this money by adding 10,000, 5,000 in your monthly maintenance? That will be a very problematic.
That may be problematic, but at this stage, Lordship, I cannot pay one third of amount. The rest amount will be adjusted somehow, Lordship, by adding more amount or paying more amount than the.
So,
But at
why
this stage,
file
Lordship,
this revision? Well, we can file a petition before the learned court.
Lordship, on that day, the learned court had directed him to pay the one third of the amount, and verbally stated that if he fails to pay the amount, he will be sent to he will put behind the bar. That is why, Lordship, he is coming before this court. He is saying that at this stage I cannot pay that amount. At least I can pay 1 lakh of rupees. So a direction may be given, that is no coercive action may be taken if he fails to pay the one third amount. Instead that he will pay 1 lakh, and the rest amount will be adjusted in installments.
Adjustment of rest amount, you see, 7 lakhs adjustment or and about 8 lakhs adjustment. It will not a matter of.
No, Lordship, maintenance amount is 15,000. Suppose he is paying 25,000 per month, 10,000 he can get, because he has to maintain himself also, and he is also suffering from various illness like kidney stone. But at this stage, Lordship, at least a direction may be so that no coercive action may be taken if he fails to pay one third. Instead, he will pay 1 lakh rupees. Next date is fixed on 13th of December. And that the rest amount will be adjusted, or he will pay anything by some more time may be given so that he can arrange the amount. His medical documents are also here.
We are not denying it. Yeah, maybe medical.
But the added court below, Lordship, after hearing the respondent side, the
Okay,
decision
sir.
was taken, Lordship.
So how long you are paying the interim? In fact, it took long time for disposal or what? Your interim was earlier?
Interim was
8,000.
8,000. It was from 8/10/2018. And thereafter, the final amount was 15,000. It was 15/6/2022, near about 5 years. So 7,000, it was, there was an accumulation. And from the date of filing, so the amount got increased. In fact, there was no delay, losses in his part in paying the amount, because he has been paying the maintenance amount 15,000 per month regularly, and it is also been admitted by the respondent number 2. I have annexed the document, Lordship. That is their document.
You have a case, but the amount is too high. It means around 8 lakhs. That is
Around
the
8
main issue to be considered.
That I admit,
Considering that aspect also, the learned trial court below had directed you to pay only one third.
One
That
third,
is be 2,50,000, whatever. Otherwise, the entire area amount. What are you doing now?
Now, Lordship, actually,
You are a service holder.
no, Lordship, I'm a businessman.
You are a business.
I'm a businessman. Now, due to my health problem, now I'm not concentrating on my business also, Lordship. That is why the problem occurs, Lordship. And I have 2 daughters right now who are living with me, and my second wife is also there.
You got divorced.
Yes, Lordship.
And Mr. KK. You are for otherwise you are formal party. I think.
Formal part.
KK handing to counsel and counsel for the petition, and also heard Mr. D.B. Rosam, the learned additional PP appearing on behalf of state respondent number 1 of the already. State is 1. Was. This is an application under section 438 and 442 railway section 528 of BNSS against the order passed in execution, impugn order against the impugn order dated 23/10/2024 passed in execution case number 17 of 2022 in FC bracket of criminal case number 88 of 2018 by the learned court of principal judge family court number 1 Kamrup M and committee. It is passed by Kamrup M.
M.
Issue notice period. Also called for the scan for DLC and so and so. Next paragraph. Heard on the interim relief. It is submitted by Mr. Handy, the counsel for the petitioner, that the present petitioner was paying regularly the interim maintenance allowance, which was fixed at rupees 8,000 per month. Since you're paying since
Since 8/10/2018.
8/10. 8/10/2018 regularly, and the final order passed in your main appeal number, case number
88/28, it was passed on 15/6/22.
88. Now case number is
FC criminal case number 88/20,
FC criminal
case number 88
88 of
2018.
2018.
Judgment was 15/6/22.
18 so and so. However, the matter was finally decided and that was passed on
15/6/2020.
15/6/2022 in FC criminal case number 88 of 2018, wherein the present petitioner was directed to pay rupees 15,000 per month. He is also regularly paying the 15,000 maintenance allowance of rupees 50,000 regularly. However, as the interim order was passed on 8/10/2018 at rupees 8,000, there was an accumulation of the arrear amount, which was around 8,79,000 as per the calculation made by the petitioner, the respondent number 2. Respondent number 2. And according at full stop, the learned principal just so and so accordingly in execution case number 17 of 2022 in connection with FC criminal case number 88 of 2022 had directed the present petitioner to pay 1/3 of the arrear maintenance, which is around 2,50,000 to the present petitioner, and the other installments.
No, Lordship. It has passed in. It has come there. There is a
1/3
huge
area.
area,
Acha. Only it is mentioned as 1/3
1/3 of
area
the area sum.
next from the next day. Directed to pay 1/3 so and so on the next date of listing. So, but presently the petitioner is not in a position to pay the entire 1/3 amount of rupees. 1/3 amount of rupees 8,07,000. No, 1/3 amount. Which maybe how much it will be?
It will be around 2,50,000.
Which may be around 2,50,000 at a time due to his health as well as financial condition. He submitted accordingly that when he gone for operation.
He was discharged on 20/11/2024 recently. That operation was carried out 17/11/2024.
As he has already undergone kidney operation on 17/11/2024, wherein he had to pay. He had to incur a cost of he incurred a huge amount of expenditure, and accordingly, it is paid on behalf of the petitioner that he may be allowed to pay rupees 1 lakh at a time, and the remaining amount in installments basis monthly, which may be added in the quantum of maintenance passed by the learned court bill. but it is seen that the arrear amount, it is a huge arrear amount of rupees 8,79,000. So uh, it may be problematic for the petitioner to pay, problematic for the problem, then it will be difficult to adjust the entire amount of rupees, around rupees 7 lakhs in the installment basis. However, considering the submission made by the learned counsel for the petitioner, the petitioner is, he is directed to pay rupees 1,50,000 at a time, and remaining amount of maintenance along with. No, we wait till next day only, na? So and so. Okay, problem. 1,50,000 per day will pay rupees 1,50,000 or not before the next date of listing. The court case before the learned trial court below, and the matter may be finally heard and decided in presence of the respondent number 2 on her appearance. List accordingly after 4 weeks. However, it is directed, the learned trial court, the learned principal judge is hereby directed not to take any coercive action against the present petitioner till the next date of order. That get ready. You pay 1,50,000 now. Let's see, but it will buy.
I love like
Call for this can copy.
that.
Only execution can be called for, I think. Scan copy.
Yes, Lordship.
Execution is separately separately.
All right.
Item 11.
Applicant order. Now, by this petition, I am seeking the zimma of a drug, my lord, which was seized in connection with an NDPS case by Gosaigaon House Police Station, my lord.
You're taking Jima of the truck.
Drug.
Your prayer was earlier rejected.
Not here, before the session post.
Yes, that's what I'm saying. Session before
My-
session.
my lord. That order is on page
Page
35, my lord. Third para, peruse the report submitted by IO. Upon perusal, it appears that the accused persons were using the seized vehicle bearing number so and so for transporting 402 kg of dry leaf substance ganja found in secret modified chambers of the vehicle. Moreover, a parcel is yet to be collected, so those is rejected, my lord. So report from the IO is required. A report from my lord.
hard check way to your Mr. Your name is
Yeah.
yes. And Ahmed is
Anand.
written as N Anand.
Anand.
Your
I'm
Mr.
Anand.
Anand you. And Anand. Bagi likhibo, and also heard Mr. D.P. Goswami, the learned additional PP. This is an application under section 528 of BNSS. Praying for grant of Jimma of the custody of a vehicle. BR registration number HR 46 F 4203. To its registered owner company, Bhabi Logistics, through the power of attorney holder, Srijay Bhagavan, the petition. Issue notice. Nalag issue notice. Call for the report from the IM. List accordingly. Yes, 1312. List accordingly on 1312.
Aliabad.
Item 12.
बहुत बेसी बहुत टाइम लगेगा ना what a submission. Yes.
My please, your lordship. Lord, this case is filed challenging the proceeding of PSC case number 96/24 pending in the court of learned JMFC Dhuri.
Hmm.
In this case, my lord, FIR at page 11, your lordship. Wife of the petitioner number 1 committed suicide, my lord. Due to mental depression, your lordship.
Petitioner, which petitioner? Petitioner number?
1. Here altogether 6 numbers of petitioner. All are out of the same family. All the family members.
You all are in bail?
No, my lord.
You are all are in bail?
No, my lord. Showing them absconding.
Oh,
charge sheet
charge sheet
submitted,
matter.
my
Oh,
lord.
acha, acha.
Submitted charge sheet, showing them absconding. Although they are permanently residing nearby the police station, nearby this.
Record may be called for an issue notice.
Issue notice for you. Again, likhibo. Issue notice. And we call for this scan copy of DLC.
Till then, my lord, the proceeding may be stayed. If possible, my lord.
It's not possible.
Till returnable date, your lordship.
No, sir. We are not staying. We are saying notice. We are calling. We have finally disposed of matter. Finally. After, yes, any you want any date or just after? After 3 weeks. After this, after 3 weeks. And if from court you are receiving any summon notice?
My lord.
Summon, no, summons you have received.
Yes, your lord. Very initial stage of appearance.
Okay.
JMFC Dhuri.
Not yet committed, I think.
Right.
Okay, we'll see.
Most obliged.
Say application lordship under 528 of the BNS lordship for quashing of the impugned order lordship kindly find. I have a very limited pair as on today lordship annexure 3, page 72. Now here lordship will find that I was absent with steps, but there was a submission made by my learned counsel that there has been no communication with my counsel. So lordship has kindly find it lordship. Consequent whereupon lordship non-bailable warrant was issued against me. And as on today lordship, because of this non-bailable warrant, I am not in a position to appear. So lordship, I want to appear. So lordship may kindly give me some protection set aside this order.
Otherwise, the case was at this stage of
This
evidence.
stage of evidence, at this stage of
So you were you remain absent for several consecutive dates.
2-3 dates lordship. Because what has happened, there was no communication with me admittedly with the council and I was not aware of the dates. And somehow I find out this certified copies lordship. So I am with a very limited prayer, if your lordship may kindly allow me to appear before the court concerned so that I can participate in the trial lordship. 5 witnesses already been examined lordship. I also do not want to.
Where is the order of 1912?
1912 lordship will kindly find.
No, next order. It was, you have annexed the
No,
order
no.
dated wherein the next date was fixed on 1912.
1912 your lordship will find. Next date is 12 lordship. 12 December.
1912.
1912, yes, 1912 for appearance is the next date. That will lordship will find in page number 70.
Your impugned order is at which one?
My impugned order, so far I am concerned, lordship, is 21/2/2024. Otherwise, I have annexed all the orders.
In page 72.
Page 70, the last order. Annexure 3, lordship. This is the order by which everything has become clumsy for me. Had my counsel not made such a submission, perhaps lordship, I would have been protected.
One order you have annexed, I don't know, 13.
I have annexed all the orders,
13,
lordship,
10.
kindly see. I have annexed the orders from 68 to 71 page number.
Dipankar.
Police. Annexure 2 and Annexure 1 are the series of the orders Lordship will kindly find from 10-10-2018 till to 9-5-2024. And Annexure 2 are the orders from 3-7-2024 till 23-10-2024. And Annexure 3 is the main order by which I am impugned, Lordship. So my humble submission before Lordship that I may be allowed to appear, Lordship, so that I can participate in the evidence. So I'm put behind the bar, nothing will be, no fruitful result will yield, Lordship. It will simply delay. And I am giving an undertaking, Lordship, henceforth I will regularly appear.
6/1/24 absent.
If you can't look at it, but he was not aware regarding the dates. Lastly, the learned counsel makes a submission that there is no communication. There is a communication gap.
Otherwise, he was absent with step.
Otherwise, he was absent with stay. And I don't know why all of a sudden the learned counsel has given this petition, this submission, Lordship. And it is a fact, Lordship, that there was some communication gap between them. Henceforth, I will regularly appear, Lordship. That undertaking may kindly be recorded.
As your against you, the NBW was first issued on 3/7,
Lordship.
because on that day your absent is condoned, I think there. It was allowed.
Lordship.
Though on 21/2, there was an order, but last part of the order, petition is accordingly disposed of, and the absentee accused is allowed to be represented by the learned counsel for today only. So, and that day, no, NBW was not issued against you, in fact.
If your Lordship may kindly see page 55, Lordship. On 26/2023, I am appearing, Lordship. Newly engaged counsel for the accused Dipankar Gupta has filed a petition bearing so and so, praying for allowing the accused to go on bail. Learned counsel of the accused has verbally prayed for allowing another date for hearing on bail. The prayer is allowed. It's fixed for hearing on the next date, so and so. Then from 26/6/2023, Lordship may kindly see that Dipankar is produced from the jail hazard. He is remanded till so and so, so and so. Considering the above, accused Dipankar Kulta is allowed to go on bail. That is 26/6/2023, page 57, Lordship. Then from there, Lordship will kindly see that I furnished bail bond on 28/6/2023, Lordship. And from there, I was present, Lordship. PWs were absent. Subsequently, what happened, Lordship, there was some miscommunication and dates were not properly intimated, but steps were being taken on my behalf. Only what happened, Lordship, the latter part, there was no step. And that is why the NBW was issued against me, Lordship.
From 21-23, there were absence.
Yeah. There was no communication with the council. It has happened because of lack of communication and misunderstanding. Lordship. Otherwise, Lordship, now I desire to appear and face the trial, Lordship. The Lordship
Yes,
may
good
kindly
Sami.
consider. What should it take, Lordship? I think for the records at this stage will simply delay it, Lordship. Because I have annexed all the documents.
The order sheets are here only.
Lordship. Let me appear, Your Lordship. I will appear, Lordship.
Heard Mr. A. Bhattacharjee, the learned counsel for the petition. And also heard Mr. D.P. Goswami, the learned additional PP appearing on behalf of state respondent. This is an application to 21 to under section 528 BNSS for quashing the impen order dated 23/7/2024 by which the NBW was issued against the present petitioner
And the
and also paid for quashing of the impen orders from 20/08/2024 till 23/10/2024 issued in consequent of the impen order dated 3/7/2024. Start. Next, it is submitted by Mr. Bhattacharjee that the accused petitioner was allowed to go on bail on 26/06/2023 and on and on 28/06/2023 he filed his bail bond, which was accepted accordingly, and thereafter he was appearing regularly before the learned trial court below. And however, he was represented by in some dates by his engaged counsel. It is also a fact that there was some miscommunication with the accused petitioner with his engaged counsel. And on 21/02/2024, there was a submission made by the counsel regarding stating that there was no communication with the present accused petitioner. And since and accordingly, since what is the order of 7/5? 7/5.
7/5.
7/5 is
7/5 probably.
was a holiday, acha.
It was a holiday, Lordship.
And thereafter, since 3/7/2024. May 7, 2024 onwards, the warrant of arrest was issued against the present petitioner. Mr. Bhattacharjee further submitted that already 5 witnesses.
Lordship, 5 witnesses.
5 witnesses are already been examined, and the petitioner is ready and willing to appear before the learned trial court below and to contest the case accordingly. However, due to miscommunication with his engaged counsel, he could not appear before the learned trial court below in 2, 3, 4 days, and for which the NBW was issued against him. Next paragraph, Mr. Goswami, the additional PP submitted in this record that the petitioner may be directed to appear before the learned trial court below and directed before the learned court below and to appear regularly before the court in each and every date of hearing. Next paragraph. Considering the submission made by the counsel for both sides and on perusal of the order sheets and other annexures filed along with the petition, it is saying that after enlargement of the accused on bail, he was regularly appearing before the learned trial court below. However, on some occasion, the steps was taken for him for his steps was taken on behalf of him, which was also allowed by the learned trial court below. However, after the order of 21/2/2024, the learned trial court below had to issue NBWA against present petitioner since 3/7/2024 and on consequence and on consequent dates and on subsequent dates. as the learned and this counsel did not represent the present petitioner. Considering all these considering all these aspects of the case, the accused petitioner is hereby directed to appear before the learned trial court below with an appropriate application for bail, which may be considered in accordance with law by the learned trial court below. However, till his appearance, next date is fixed on
19/12/24, Lordship.
however, till next date of listing, that is on 19/12/2023.
24,
The
Lordship.
24, the NBWA issued against so and so shall remain, shall be stayed or be suspended with the above approach assistance disposal.
Deployed.
Okay.
May please your lordship, the criminal petition against the order dated 27/5/2020 issue invariably against the petitioner. Lordship. He has never received the any summons.
Small.
No received the summons. Lordship. He's the
But he was showing as an absconder in the charge sheet. or
no.
Huh?
He's on bail.
He was on bail,
Bail. Lordship. But
anticipatory bail.
Anticipatory. He is not received any summons. He is the Assam police. Lordship. Petitioner is the Assam police.
Let's go some.
Lordship, the case 10 lordships. Available warrant was issued against him, lordship, because someone issued not returned. If one I get this, the legal officer like it's suffering.
Someone issued not returned.
Last was 27/15/27. 27/5. Accused Abdul Majid is case 31 lordship. Case 33. 33. 5 copies, 43. 31 is the last loss. 27/5. The accused Abdul Majid is absent. Available warrant of ₹3,000 is returned with execution in the report and issue NBW against the accused.
That means you received the BWA. Available warrant you received.
No receipt.
But you had returned after execution only.
The someone received lordship, that he is not received. He is the on
Now
duty
you
lord.
said that you have not received someone. Now you're saying that you have not received BWA. Which one have received?
So I
Because BWA is returned after service.
lordship.
As per the order, I don't know.
Lordship, as per order. So I've not received lordship. But he got the anticipatory bail lordship. You are well aware of the fact. That he case. That is the trial lordship. That the service.
Trial is okay, but we have nothing apart from that. Now, why court is of the opinion that he have received the summons? Do one thing,
I
we'll
feel
call
the-
for the scan copy, then we'll be, because he has not annexed the other things. We can dispose of the matter in that way. Where is the order date fixed? When?
There's a 6/12 lordship.
6/12. Prior to that, we
Lordship,
are
I
fixing
feel
it.
the trial lordship. I appear for the trial. So it's-
Okay, prior to that.
No, but you have not annexed anything. I mean, you are saying, once you are saying that you have not received
the
someone,
lordship.
then you are saying that you have not received the BWA, whereas the order is there that the
All-
BWA is returned after execution.
Lordship, all order is their lordships.
All
And-
orders are there, but
lordship.
you are saying that you have not received, but
Lordship.
here it is, you have received.
Lordship is our.
That is why.
I am on duty lordship. He's the Assam police lordship. They pay 10 lordship. The I appear before the trial for lordship. Police woman. Due to the चलेगा नहीं
Where is the anticipatory bail order? Have you annexed?
no lordship.
Then how can we say that you are in bail?
Lordship with the subsidy is there lordship.
Class it is there.
Hmm.
And which page? You have annexed this charge?
Nothing, Lordship. And next, Lordship, Barnum Lopez, 19, Lordship, honors,
19.
19, honors.
You are Abdul Majid.
Abdul Mazid, Lordship.
Your bail or anticipatory bail? What is the section against you?
392.
Huh?
392, Lord.
392. You are a police officer and 392 is there.
Yes, Lordship.
Very nice. Big over.
It helps that file, Lordship, recall the Yes, sir.
You can, if he wants to appear without any protection, then court will decide. Otherwise, with
Because
co-
till now, though, there is no NBWA.
NBW.
We'll reflect your submission here. But NBWA is not yet issued. Where it is issued, NBWA, no, not yet.
Yes, issue, Lordship, NBW. Recall the NBW, Lord. I appeared before the trial court on 6th December.
Order issuing NBW, oh yes.
Which order your NBWA was issued against you?
34, Lord. 27, 5, 24, Lord. Barnum, Lordship, last portion, Lord.
Twenty-seven 5.
27, 5.
No, what is your stand? You have received or not received?
Lordship, he informed that someone received, but he is on duty. Lordship, when the police is his home and search him, he knowledge the case, Lordship. He is on duty, Lordship. Someone received, Lordship. I appear as the trial, Lordship.
You, Mr. N. Ahmed, no?
And
Heard Mr. N. Ahmed, the counsel for the petitioner. And also heard Mr. D.P. Kusami, the learned additional PP appearing on behalf of state respondent. This is an application under section 528 BNSS for setting aside and quashing of the order dated 27/5/2024. Whereby the learned CGM Kamrup M. Guwahati issued NBWA against the present accused petitioner in PRC case number 282/2022. Next, right, is submitted by Mr. Amit, the counsel for the petitioner, that the accused that he is he's a police officer.
Assam Police, Lordship.
He is working as a what strength? He is
UBC, Lordship.
he is a
Sorry,
he's an employee in the Assam Police and working as a UBC. And presently, where is the present posting? Have you annexed anything? So present place of posting?
Earlier he posting in Jalukbari and later on he just followed.
That also is not clear.
No, Lord.
Then how can we say that he was in duty and all?
Lordship. Earlier
Bring
posting,
something at least in the record. Simple petition you have filed, such a petition, nothing is there. Presently posted Diwan Alagaya. So and so, and at the time, by relevant time of incident, he was posted at Jalukbari PS. However, during the investigation, he was granted with the privilege of anticipatory bail. After filing of the charge sheet, the learned trial court below had issued summon. And once in one occasion, he received the summon, but as he was on duty, he could not appear before the learned trial court below. And considering his absence, the BW was issued, but he was not aware about the issuance of any BWA against him. However, he is ready and willing to appear before the learned trial court below on each and every date to be fixed by the court and to contest the case accordingly. He further submitted that he being a police officer, there is no chance of any absconding, rather he will appear regularly before the learned trial court below. Next para. Mr. Goswami, the learned additional PP submitted in this regard that the petitioner may be directed to appear before the learned trial court below with an appropriate application for bail, which may be considered in accordance with law. Next para. Hearing the submission made by the learned counsel for both sides, I have perused the case record and the annexures file along with the petition. From the charge sheet, it is seen that the accused was on bail and the summons was accordingly issued against him after submission of the charge sheet. However, as he failed to appear before the learned trial court below, the bailable warrant had to be issued. And after execution of the same, the learned trial court below had issued the NBWA against the present petitioner. However, considering the entire facts, circumstances of this case, and also considering the fact that the accused was on bail during the investigation, I find that one more chance may be given to the present accused petitioner to appear before the learned trial court below with an appropriate application for bail, which shall be considered in accordance with law. It is also submitted that the next date of listing is on 6/12/2023, and accordingly, till the next date of listing, that is the accused honor before the next date of listing, the accused petitioner is hereby directed to appear before the learned trial court below. However, till then, the execution of, till next date of listing, the next date fixed by the learned trial court below, the execution of NBWA issued against the present accused petitioner shall remain still or suspended. With the above observation, the criminal petition is disposed of at the motion stage.
Development.
Okay. It's a 528 BNS, your lordship, for passing of a PRC case number 430 of 2024, as well as a search sheet, your lordship, arising out of Dutno PS case number 33 of 2024, your lordship. Actually, what was happening, your lordship? A FI was filed by the mother of the petitioner number 2 against the petition number 1 by stating that the petition number 2 was kidnapped by petition number 1. But however, the petition number 1 and 2 is a husband and wife, your lordship, presently. If your lordship will see the FI at page number 20. It is the Bharni Pilla type copy at page number 17. May I read, your lordship? Page 17 is the type copy, your lordship. Good officer in charge, Dudnoy Police Station, date 3/5/2024, subject FIR. Respected sir, with due respect, I would like to inform you that on 26/4/2024, my daughter Sakshi Das, aged about 20 years, father of Dibaka Das, village Kolitapara, PS Goalpara, district Goalpara, went to the Dudnoy College, and we came to know that one person named Onuj Ahmed, that is the petition number 1, son of Nasiruddin Ahmed, village Goroimari, PS Goroimari, district Kamrup, Assam, has kidnapped my daughter from Dudnoy College. After searching thoroughly, it is indeed true that the accused has kidnapped my daughter. Therefore, requesting you to recover my daughter and to hand over us after investigation the matter. And accordingly, a case was registered under section 366 IPC, your lordship, being Dudnoy PS case number 33 of 2024. And your lordship, the petition number 2 went to the police station on 14/5, and after that she went to before the honorable court of the CGM Gwalpara and recorded her 164 statement at page number 24, Your Lordship.
34.
24, Your. Please, sir. May I read, Your Lordship?
No, it's okay.
Statement-
I've seen.
Yes, Your Lordship. If Your Lordship will see the second page number 25, she herself stated that I am in love with this petition number 1, and in the year of 2022, I left my house. And when my parents as well as my family put pressure on me to marry with some other person, other groom, they are searching other groom, I eloped with Anuj Ahmed. And if Your Lordship will see page number 22, that is the order of the Honorable JMFC Elizabeth Hazarika, Your Lordship, dated 14/5/2024, where it is reflected her age. The victim has stated her age to be 21 years. The record also revealed the same, as such she is major. Your Lordship, accordingly, the IO is directed to allow the victim to go to her choice of destination after verification, obtaining a bond of ₹2,000 to their satisfaction. Send back the CR to the concerned forum. And page number 23, Your Lordship. Later on, the IO concern shall ensure the safe passage of the victim to her choice of destination. After this order, Your Lordship, she went to the house of the petition number 1. And Your Lordship, they have applied for register their intended marriage under the Special Marriage Act. However, Your Lordship, when they have applied the marriage, the Deputy Commissioner, the concerned officer of the Deputy Commissioner was refused to register their marriage. And they have imposed a condition that for register your marriage, your parent has to be present as witness. After that, both of the petitioner has approached this honorable court, page number 34, and seeking permission to register their marriage. If Your Lordship will see Annexure 6, page number 34, Sakshi Das, that is the petitioner number 2, and Anuj Ahmed, that is the petitioner number 1. And after the intervention of this honorable court, Your Lordship, on 18/9, their marriage was registered at page number 39. Now, Your Lordship, a PRC case was registered against them, against the petitioner number 1, as well as against the father of the petitioner number 1, who is a college teacher. If Your Lordship will see page number 48 and 49, charge, page number 49, Your Lordship, where they have mentioned in the vernacular, if Your Lordship will see vernacular page number 51, they have mentioned, the police has mentioned the ছোৱালীজনী উদ্ধাৰ কৰা হ'ল আৰু medical কৰিবলৈ পঠিয়াই দিয়া হ'ল. But in the 164 statement, she herself stated, I by myself went to the police station. So this is completely a manipulative case made by the police. And this is not a matter of 366, Your Lordship, where the girl by herself stated that I'm in love. In the year of 2022, I eloped. Now, in the year of 2024, I again elope with the petitioner number 1, as I'm in love with petitioner number 1. So this is not a matter of 366, Your Lordship. And now presently, they are both a husband and wife. On 10/11 also, they have thrown a party in their village, Your Lordship. So the essential ingredients of 366 already missing, Your Lordship.
Case is still under investigation.
No,
No, Sarsited, Your Lordship.
Charges
Yes.
submitted against the father also.
Yes, Your Lordship. And Your Lordship, actually, we have also filed a criminal petition for quashing against the FIR by the petitioner number 1. And that criminal petition is registered as a criminal petition number 730 of 2020. Still pending before this honorable court. In that matter, actually, petition number 2 was not as party. But in this matter, we have made her party, Your Lordship.
Your Lordship, at this stage, record may be called for issue notice to husband and
We are
going for
not
accused of
paying for the
torture.
interim protection, Your Lordship.
Going for record, Lordship will decide on the next Lordship. Along with the case die also.
I'm paying for
So the
interim
matter is
protection, Your
Sarsited.
Lordship, because 164 statement is there. And Your Lordship, if Your Lordship will
You mean
see.
interim protection means that petition number 1 is shown as an absconder or he was unjailed?
Nothing is so bad.
Then what kind of interim you need?
Pardon, Your Lordship.
What kind of interim you need?
What
Stay
state of matters, Your Lordship, the PRC case number 430 of 2024, because this is the abuse of process of the court, Your Lordship. then it is also violating the Article 21 of the petitioner, your lordship. In this regard, I would like to place on judgment of the Honorable High Court, Allahabad High Court, your lordship.
Here your father is not here.
No, he has filed in another criminal petition, your lordship.
So another petition.
Yes, your lordship. If your lordship will see this judgment in para number 8, your lordship.
No, we'll file it afterwards.
Yes, your lordship.
Your MS as well.
Yes, your lordship.
Otherwise, Mr. Goswami, I've seen that our 164 statement is there, and it did the relevant time of incident. She was not a minor, in fact. She was a major. So maybe, but
Lordship.
heard Mr. S. Bhuya, MS S. Bhuya, the learned counsel for the petitioner, and also heard Mr. D.P. Goswami, the learned additional PPA paying on behalf of state respondent. Baki hi likhi dibo, listen application, so yapa likhi dibo. Issue notice to the respondent number 2, no formal notice is required to be served on so and so. However, during the course of the day, the extra copies of the petition may be served to the state respondent number 1. Full stop. Call for the scan copy of the LCR. Mr. Expera in the interim. In interim, the proceeding
PRC case number 430 of 2020.
pending before Chief Judicial Minister,
Yes, your lordship.
pending before CGM Golpara in PRC case number 430 2024. We state in respect of the petitioner number 1. Petitioner number 1 is the accused
Yes, your lordship. We say.
against the petitioner number 1. Till next date of listing. List accordingly after 4 weeks.
If your lordship permit, then the criminal petition number 730 of 2024, your lordship, take both of these matters.
Further, the criminal petition number, yes,
730 of 24.
730 of 24.
Yes, your lordship.
Criminal petition number 730 of 2024 be tagged along with the present petition.
Applies, your lordship. 16.
Yes.
There is an application under IT and BNS, setting aside an order of NBWA, should the interim order is at page 53, lordship. Order dated 9/7/24, lordship. The brief of the case is that petitioner, although cognizant was taken on the year 2018, that the petitioner received the summons only in the month of February 24. Right after receiving the summons, lordship, on petitioner, although he could not appear on the date 19/2/24 due to some illness, which was engaged counsel by taking steps has appeared before the court.
We have not annexed the other order sheets.
Yeah, we have the next lordship. It starts from
Page
page
44.
number 43. It starts lordship.
So he wasn't earlier, he was on bail.
Yes, lordship. The bail order is in page 50, lordship.
Then during investigation also, he was on bail.
Yes, lordship. Limited bail, lordship, he was only absent on one day without state, lordship. That very day, the petitioner's father had to be hospitalized, and due to some miscommunication, his engaged counsel also did not know about the circumstances. So by the time it was too late on that day, so Ramit trial court issued the NBW. Should may set aside the order
So you are challenging the order of 9997.
9/7/24. Petitioner is a college professor, lordship, he will cooperate in the trial process.
Yes, Goswami, otherwise it seems that he only one day he was absent. You are Mr. N.
And the children.
Heard Mr. N. D. Chaudhary, the counsel and the counsel for the petition. Also heard Mr. D. P. Goswami, the learned additional BP, appearing on behalf of state respondent. Stop. This is an application under section 528, with section 438 of the 442 of BNSS for quashing the of now for posting and setting aside this order dated 9/7/2024 in PRC case number 1627 of 2018. Passed by learned additional CGM Kamrup Metro Guwahati, and whereby this NBW was issued against the present petitioner. Next one is submitted by Mr. Chaudhary, the learned counsel for the petitioner. That present he is working as a doctor or
College professor, Lordship.
college professor. He is a college professor and presently discharging his duty from as a principal
Assistant professor in Pragyotis College.
assistant professor in Pragyotis College, Guwahati, full stop. He was, after receiving summon, he was regularly appearing before the learned trial court below. And on 9/7/2024 only, he was absent without step as his NBS counsel did not take steps on behalf of him, and for which the NBW was issued by the learned trial court below, fixing the next of listing on 30/12.
Yes, Lordship.
30/12/2024 for his appearance. He is ready and willing to appear before the learned trial court below and to contest the case if he will contest the case. He wants to appear before the learned trial court and want to contest the case. And accordingly, he submitted that the NBW issued against him may be stayed or suspended, giving an opportunity to the present petitioner to appear before the learned trial court. Next one, Mr. Goswami, the learned additional PP, submitted in this regard that the petitioner may be directed to appear before the learned trial court below with an appropriate application for bail. Next one, considering the submission made by learned counsel for both sides, annexures filed along with the petition and other aspects of the case, the present accused petitioner is accordingly directed to appear before the learned trial court below on or before next date of listing, and till date the NBW issued against the present accused petitioner will be stayed or be suspended. With the above observation, the present so is disposed of at the motion stage itself.
Much of the Lordship.
17.
None appears on call for the petitioner. List the matter accordingly after 1 week.
19.
May I please, Your Lordship? Here, Lordship, we are before the Honorable Court against the NBW order passed on 17/9/2024 in special case number 311 of 2024, pending before special judge Goripur in Goripur PS case number 758. Lordship, pending before special judge Dhubri. What happened, Lordship? I have filed this petition on 14th. On 18th, the next date was fixed. However, on 18th, what order has passed? Still I don't know. So Lordship may kindly call for the record. In the meantime, I will file additional affidavit annexing that order. On 18/11.
Otherwise, you are showing an absconder.
Yes, no, Lordship. Yes, hardship file showing absconder, Lordship. Only 2 dates I couldn't appear. Only one NBWA order was passed, which is I have annexed at page number 21, the last page. By this order, NBWA has been issued. And Lordship, date was fixed 18/11. But Lordship,
No, only that order you have annexed.
yes, only that order I have annexed. So Lordship may kindly call for the report. And on 18/11, it was fixed. And on 18/11, what order has passed, still I don't know, Lordship. So call for the record. In the meantime, I will file additional affidavit.
And you file additional affidavit, annexed all the order sheets. in
Obliged,
fact.
obliged,
Otherwise, as you have
Obliged,
submitted that
madam,
you
obliged.
appear, it's not here, in fact.
And next date is fixed 4th of January. So Lordship, in before vacation, in the month of December, list this
Right.
matter along with directing for producing the case report.
Okay. Heard Mr. B. Gogol, the learned,
G. Soma.
G. Soma, the learned counsel for the petition, and also heard Mr. Benso. Additional PP, Mr. D. P. Goswami. And Baki, this is an application lihibo, reply or for the scanned copy of the case record. And Mr. Soma is also hereby asked to file the additional affidavit, bringing all the order sheets in the record. List accordingly, in the month of December only you fix it. It has to come from which place, Mr. Soma?
It is from Goripur, Hubli.
Even 18.
Second week of December.
Second, we're trying, second week of. He's suggesting on 18. If it comes on 18, we may
18,
dispose of the matter itself on 18.
Because on 4th of January, it is fixed.
Okay, we'll try.
Obliged.
And suppose if records comes or not, it is different aspect, but you try to file
Yes,
the
yes,
additional
yes.
affidavit, annexing all
Yes,
the order sheets.
Yes, obliged, my lord.
Item 20.
My lord, this may be done. My lord, the petitioner is arrested.
Already arrested. Pure Mr.
And Islam.
For Mr. N. Islam, also her so. It is submitted by Mr. Islam that the petition, the present petition has already become infructuous as the petitioner already got arrested in connection with this case.
Yes.
Matter is accordingly disposed of as already infructuous. Hope it's been disposed of.
51 of the supplementary list.
He was to it. What was it? ইমান দিও নেকি মোশন একদম আগবাঢ়িব পৰাই নাই আপুনি ইমান ইমান বেঞ্চন হলে ফটাফট হৈ যায় ইমান লাইন শুনি দিব লাগে চব পচিবল না আমাৰ কাৰণে yes
Yes. It is an application against the Interim judgment and order dated 10/9/2024. Passed in criminal appeal number 6/23 by the session court Bozali. You know, I have annexed at page 55. You know, in this case, you know, the learned appellate court has direct upheld an order dated 13/6/2020, passing complaint case number 143/16 that I have annexed page number 28. But what happened, you know, in that case, the case was filed under various sections of the VA, you know, and accordingly, without considering the evidence and affidavit, which was affidavit on assets and liability, which was compulsory. As it was ordered by the Supreme Court in the Rajneesh versus Neha case, that was not happening. That's why I am come before this honorable court that I am not satisfied with the order of the trial court and appellate court also. That's why I have come before this honorable court. But I am ready to pay any amount as it is ordered by the trial court. But at this stage, I am waiting before this honorable court that I am not
satisfied at all on the judgment and order passed by the trial court and appellate court, Your Honor. What order was passed, Your Honor? The learned trial court in the trial case directed me to that the petitioner is prohibited from any further act of domestic violence upon the respondent or aggrieved party or aid in or abetting such act upon her, number one. Number two, the petitioner is directed to provide for a shared household as the respondent aggrieved party has a right to reside in the shared household which belongs to the petitioner if the respondent aggrieved party wishes to return and shall not be evicted without following the due course of law. Moreover, number three is that overall the petitioner is directed to pay a monthly amount of rupees 8,000. That part I have objected on because that part was the learned trial court had observed without observing the apex court order, which was compulsory as it is instructed by the Supreme Court in Rajneesh versus Neha case. That what happened, in any maintenance relieving case before husband and wife, in Rajneesh versus Neha, it was strictly instructed by the
Yes, for assets and liabilities.
yes. That was not observed.
Okay.
So next date is fixed on 28/11, just after 2 more years. Okay, in the meantime, I may be as an interim.
No. Can
The
I wait
interim
not
order may
pass?
be
Can try to dispose of the matter on the next date of listing itself, but interim cannot be there. You take
on the next date. Let's see.
Yes,
On the next date, 28 November, the Honorable Trial Court has directed me to pay the amount.
yes, you pay. We'll see to it
No,
if it is
I will pay.
supposed.
But till then, in the disposal of this, I may be protected.
What kind of protection you need?
Protection may be what happened, the interim or
You are insisting that no payment should be there. Order of that
till
kind
the
of.
disposal.
Mr.
The interim order may be.
Kakoti, the counsel for the petition. This is an application under section 438 and 442 of the BNSS against the judgment and order dated 10/9/2024 passed in criminal appeal number 06 of 2023 passed by learned session judge Bojali by the order of learned trial court below was affirmed.
Yes. On that is fixed on 28 November.
No.
That's it. Order dated 10/9/24 passed in criminal appeal 6/20. I have challenged that order.
No.
I have
Yes,
annexed
obviously, but the order passed by the magistrate is
at best 28.
No, 28 is okay. What is the number in the case?
Case number, complaint case number 143/16. CR case,
Case number
143/16.
16.
2016. That was.
And the judgment order was passed, judgment and order was passed on
13/6/2023.
13/6/2022 by
the judicial magistrate at Bozali.
JMFC Bozali. JMFC Bozali.
Yes, judicial magistrate first class at Bozali.
Issue notice to you. The respondent who registered it is so and so. Also call for the scan copy of the LCR. No. It to LCR copy. LCR.
In the impugn order may be stated.
List accordingly. There is no any kind of interim order where
No,
it's interim order.
the impugn order may be stated.
Next list after 4 weeks. No stay will be there.
Let's see.
Cannot be stayed. Okay.
52.
Yes.
But the matter relates to disproportionate of assets, my lord.
Yes.
Here, Lordship will find the FIR at page 26, Lordship,
26.
and the type copy at page 27, Lordship.
Yes.
But, it was filed by the CID, Malad. And a reliable source, may I read, Lordship?
Yes.
A reliable source has informed Sri Ranjit Das, so-and-so retired Deputy Chief Engineer. That is, this FIR was filed after my retirement of 7 months. Since I was retired on 28th of February 2021.
28th of
February 2021. And this FIR was lost on 30/11/21, about 9 months. Then Lordship will find this FIR, Lordship will find at page 27. A reliable source has informed Sri Ranjit Das, retired Deputy Chief Engineer, Construction Survey, Maligaon, Guwahati, has acquired huge property which is disproportionate to his known source of income. He was the employee, Deputy Chief Engineer of Railway, NEF Railway. As per the available information at the beginning of the check period, that is 1/1/2013, he was having assets like property or one plot of land measuring 1 kattha land, holder number so-and-so 171, ward number so-and-so, one flat 1200 square feet, Adabari, Guwahati, along with cash reserve in approximate so-and-so 28 different bank accounts, including savings accounts, FD, RD, to a total approximate amount of rupees 48,27,474. Whereas at the end of check period, that is 31/12/2019, it has been learned that one residential building has been constructed on that 1 kattha land, ward number 17, Jorhat, which as per available information has not been declared in the office, whereas the case reserve in those different bank accounts, including saving accounts, FD, RD, has increased to an approximate amount of rupees 96,02,392, thereby resulting in total asset value of at the end of check period, that is 31/12/2019, to be rupees 1,28,29,892. As per the information available, Sri Ranjit Das also has one 4-wheeler vehicle which cost around rupees 10 lakhs. It is also seen that Sri Ranjit Das has made a lot of investment like LIC policies, 22 different portfolios of mutual funds, etc. Besides hefty cash credit transaction in 12 different savings accounts, ranging to total from 40,000 to 1 lakh every month to on an average. The income of Sri Ranjit Das, retired Deputy Chief Engineer, Maligaon, Guwahati, during the check period from 1/1/13 to 31/12/2019. Malat, this I must say, Malat, since he is working 1995, Malat, only the check period has been taken into consideration for this disproportionate of assets, Malat. 1/1/13 to 31/12/2013. Here, Malat, actually, whatever the deposits were there, recurring deposit, fixed deposit, whatever the amount were there, those amounts were matured. And subsequently, it was rolling down and the amount was fixed again in the other accounts. And now, without considering that aspect, now abruptly for 7 months, 7 years, they are taking the where from this amount has come. So, and that part, well, since I have, I am a income tax payee, my lord, everything has been correctly measured, and that whatever they have shown the excess amount on presumption, my lord, that is not correct. My lord, I have the audit report already. I have annexed, my lord, that part. Where is 2 point something, my lord? It is minus, my lord. My savings is minus, my lord. And they are showing somewhere here, lordship. Again, I'm reading, my lord. It will be helpful, my lord. It is also seen that Sri Ranjit Das has made a lot of investments, so-and-so. Now, 1 crore, lordship, will come to line number, check period from 1/1/2013 to 31/12/2019 is around rupees 1,83,661, and the expenditure during the same period would be around rupees 68,71,220. Thus, the asset acquired by Sri Ranjit Das from legal known source during the check period is around 1,83,000 minus 68 32,12,441. Whereas the net value of asset acquired during the check period is around approximately 80,05,418. This stand approximate 47,92,977 in surplus. Thus, prima facie, it appears that Sri Ranjit Das, Deputy Chief Engineer, Construction Service so enriched himself during the check period and the extent of disproportionate asset is around 47,92,977, and the percentage DA comes to around 47.53%. Under the above facts and circumstances, it is prima
It's
facie.
a long FIR, where is the calculation is there and
Now,
around the
yes.
judges
Now,
of proportion.
this is the FIR. My lord, lastly, Lordship will find 727B.
That's the SS.
Yes. Thus, prima facie, it appears five number lines. Thus, prima facie, it appears that Sri Ranjit Das, Deputy Chief Engineer, Guwahati, enriched himself during the period and 47.53% under the above and the case has been registered under section 13(1)(e) of the PC Act. Now the 13(1)(e) of PC Act is already amended, my lord. It is nowhere, my lord, by virtue of 2018 amendment, my lord. And under section 13(1)(b), it is there, my lord, of PC Act 1988 as amended in 2018 and endorsed to Sri Sapanti Hazarika, Inspector, CBI, ACB, Guwahati. Now, my lord, after this, they have submitted the charge sheet, lordship. That is page 29, lordship. 8/11/2013, my lord, or 23, my lord. That is about from my retirement, it would be about 30 months, my lord. About 30 months after my return. Then lastly, I will show the lordships the year in the charge sheet, my lord. Lordship will find at page it starts from 76, lordship. Last portion. I will not read out all these things, my lord. Just the computation of disproportionate asset loss.
Yes.
Lordship has found it. Statement: asset of the beginning of the check period 98,09,683, and asset at the end of the check period 1,91,24,829, and income during the check period statement C 2,39,30,149, and the expenditure during the check period statement D 3,61,43,000 something, and a BA assets, these assets acquired so 93,000, and now 8 serial number 8 DA statement E statement C. Now in the charge sheet it has been enhanced to 89%, 89.96% from 47 to. Now this is the charge sheet, my lord. And lordship will find the charge was framed on annexure D, page 29, lord. Oh, my lord, before that, my lord, sanction order, my lord. 87, my lord. Annexure C, page 27, my lord. It's very interesting, my lord. My lord, it is only small page, my lord. The mainly, my lord, this para 2, and whereas after conducting the investigation in the matter CBI so and so, known source of income subsequent to this one. Number 3 is important, my lord. Para 3. Totally non-application of mine, and it is already without being heard to the petitioner, my lord. Now, therefore, the president, the competent authority under section 19(1)(a) of PC Act 1988 to remove the said Sri Ranjit Das from the service. My lord, after my retirement of about 30 months, how can they remove the petition Ranjit Das from service after carefully considering the materials relevant to the case placed before him in respect of the said allegation, has granted sanction for prosecution against the Sri Ranjit Das agent. But totally non-application of mine. And here I have gone through the report of so and so, and this is my lord, whatever in general this is there, my lord. I have gone through the report of CBI so and so, and other relevant records of the case after careful consideration of the matter in the light of facts of the circumstances and so and so. My lord, and the sanction is hereby accorded under section 19 of the Prevention of Corruption Act 1988 as amended 2000 for prosecution of Ranjit Das under section this. My lord. Now, next, my lord, Annexure D 89, it's a charge was framed, my lord. After considering all this, taking cognizance of this charge sheet, all these things, then only the summons was issued to me. Then accordingly, I appeared before the Honorable Court, my lord, in the CBI. I took the bail. I'm under the terms and conditions, regular bail one. I'm in the bail, my lord. And my lord, after appearance, my lord, then this charge was framed, my lord, where we have submitted our rejoinder, all these things, taking all these pleas, but it was not considered, and thereby court came to the conclusion that Lordship knows about the framing of charge, my lord, and lastly, page 98. Page 98, my lord, last line, the charges are read over and explained to accused, to which he pleaded not guilty and claimed for trial. Now, Lordship will come to the audit report of the petitioner, my lord, his income, my lord. Page 99, Lordship. Particulars, I will show only all these particulars, my lord. Now, Lordship, the last page, my lord. 127, my lord. The percentage of disproportionate asset, my lord. Here, my lord, this statement I have shown in my petition, my lord. The Lordship will be very much clear, my lord, regarding charge sheet and my audit report, my lord. The comparison I have seen given, my lord. In my petition, Lordship kindly have a look at.
It's okay now. As per your audit,
Minus, it is minus 2.04.
but it was audited by a person, your person, chartered
The
account.
competent authority, it's chartered accountant. Chartered accountant, because taking all my property, all my the bank statement, whatever it is, because the CBI when it was inquired, my lord, on presumption they collected, and most of the savings, most of this amount which I acquired through my wife or through my house rent. And I have the house in 1998, but now they are saying that it was purchased in 2000 after 2013. Cannot be, because it was the house of constructed by my father, and father was also the railway employee, the officer. And how can it be taken into consideration all this aspect? And had there been, my lord, had there been the calculation from the initial period, certainly I would not have been before this honorable court today. Because of the calculation, now they have made some in the FIR 47, in the charge sheet 89. Again, as per my report, Lordship, just for a look, my lord, consideration, my lord. And they have also taken kitchen expenditure 33% of my salary. 33.33. Only 2% who have the husband and wife, and they are the Brahma Kumaris sect. And Brahmapura, even these petitioners and wife do not take the meat. They are totally vegetarian, no onion, no nothing else, my lord. Only they have the ashram. In the ashram, they most of the time they take the food. Even in 33%, it has been shown. Lordship, this comparison I have shown, my lord, that is, Lordship, kindly have a look, my lord. Just for a minute. Just for a minute. Page para 22, my lord. Page 18, Lord. It is very much crystal clear, my lord. Statement, my lord, asset at the beginning of the check period with effect on 1/1/13, they have shown 98 lakhs 9,000, whereas my asset was 1 crore 79 lakhs 31,120. And second, asset at the beginning of the check period statement, they have shown 1 crore 91 lakhs. It was almost 1 lakh is different, my lord. 1 lakh. Yes. Income during check period statement C. Here they have shown 2 crore 39 lakhs. But whereas my statement income was 3 crore 54 lakhs as per the known source. Law source, my lord. It is not illegally. And there was no complaint at all during my service life. And expenditure, next, my lord. During check period, they have shown 3 crore 61 lakh, whereas it was 3 crore 35 lakhs 95,000, and 25 lakhs is excess. And here 90 assets acquired BA 93 lakhs 15,000, whereas it is 11 lakhs 47,000. Excess it has been shown. And CD likely savings they have shown 1 crore 22 lakhs, whereas as per my savings, my lord, only 18 lakhs 71,000. And this is, they have shown totally in tune of 2 crores 15 lakhs 28,000, whereas I have the 7 lakhs 23,653 in savings.
Yes,
So,
Mr. Allen. So this disproportionate or the table they have prepared is not
correct. Simply, I have been harassed, my lord, and probably, my lord, they did not calculate the whole things. Had there been the calculation from my service period itself, then each and everything would have been come. And certainly today, I would not have been before Lordship, my lord. And because of this wrong calculation, miscalculation, my lord, now I have been suffered. These are the things.
Yes,
Lordship, the petitioner has basically hammered 3 points. One is sanction and the period of lodging the FIR. FIR has been lodged after getting certain information, Lordship. And check period, Lordship, in VA case, Lordship, there is always a check period. It is not that without the check period, they will calculate. Check period has to be there. So therefore, check period has been written. And during that check period, Lordship, materials were found by the IO of this case, and accordingly, Lordship, charge sheet has been filed. There definitely will have to be a difference because at the time of lodging of the FIR, we have not investigated. Only on the basis of source information, we have registered the FIR. And during investigation, after calculating the amount derived from their account and the other things, Lordship, it has come to that. Therefore, there is a difference. That difference has to be there, Lordship. Therefore, subsequently, Lordship, with regard to sanction, the law is very clear on the point of sanction. If their stand is that he is a retired government servant. For retired government servant, no sanction is also required. Then I think
apart from that, opportunity of hearing is also necessary as per the Supreme Court.
Let me complete, then we make a sentence. For retired government servant, no sanction is required. That's a settled law. And your Lordship, they have shown the sanction order. I fail to understand what my learned friend would like to refer it. Lordship may kindly have a look into the sanction order. Now, page 87. Counsel for the petition has relied upon the para 3. Now, is the lordship got it, sanction, and now therefore the president, the competent authority and under section 19A to remove the so and so from the service after careful consideration. So what is wrong, lordship? Or if the petitioner who happens to be the who is serving as
Chief engineer.
Deputy chief engineer.
mayor, so and so, deputy CE survey, so and so. Or at this post, the appointing and removing authority is the president of India. So therefore, in view of the authority, he has been removed, there is nothing wrong in the sanction.
No, he is insisting that after his retirement, the word remove is there.
Lordship, law is very clear, sanction is not
That is
required.
Non-application of mine.
For a retired government servant, sanction is not required, it's a settled law, lordship. A settled law. I don't know why sanction has been, obtained. There has to be assertion, but might be, lordship, that during the check period, one more law is there, lordship, if the offense has been committed while he is holding the post, then sanction is required. If the offense has been committed during his service, lordship, then sanction is required. So I think I don't know when he has not annexed any document with regard to his service tenure.
That statement is there.
Statement is there, but now.
Okay, then at present, we call for this scan copy of case record.
Okay, from the record, their petition itself doesn't deserve any merit, lordship. Has to be dismissed at the outside, I mean, right now, lordship. There is no ground. And secondly, they have referred to their own
Statement, yes.
document relied by them, lordship, by the defense. So, lordship, the account statement and all, at the time of framing charge, the documents relied by the defense has not to be considered. So that is also Devendra Kumar Padhi, lordship. Clear.
Yes, yes.
So I don't think, lordship, notice should be issued at this stage, lordship, because the petition doesn't deserve the merit to be considered, lordship. We're wasting of court's time, lordship, nothing else, lordship, because consideration charge, lordship, prima facie case has to be made out. And lordship, from the documents available from they have annexed, available on record, they found after calculating this is the amount which is disproportionate to his known source of income loss. Accordingly, it's been paid, lordship. Where is the wrong option? Let them contest, lordship. During trial, they will get the opportunity to get the give the account, the audited report. That is their document. This is not the document relied upon by the prosecutor, if I'm not wrong.
It's their document.
It is their document, lordship. So, lordship, my humble prayer, lordship, not to even issue notice, lordship, at this stage.
Okay.
Since all the documents, my lord, I have relied on, and these documents itself says that there is irregularity. And they are just excessively doing all these things just to harass the petitioners. Sanction order, there was no opportunity. Latest Supreme Court decision says 2023, the Honorable Supreme Court says that when administrative action is taken against the person, if he is adversely affected, the opportunity of hearing is must, my lord. Without opportunity of hearing, the whole proceeding is liable to be struck down. This is the Supreme Court has said recently, 2023, my lord.
Moreover, lordship, one more submission, lordship. They got the opportunity during the consideration of charge, lordship. They got the opportunity to, submit.
Have you filed any during the time of consideration of charge? Your petition was there, I think,
Yes.
for appearing for discharge.
Yes.
Those things were considered.
No, that has not been considered.
Lordship, then they are not entitled even during the consideration of charge.
That has not been considered.
Let me say, if they have not raised that issue, how they can claim?
No, that has been raised.
But
That
the
has been
order,
raised.
but the order of framing charge,
But
the order of framing charge doesn't reflect so.
It is there. Even I have a.
They have not annexed any petition where they have challenged the sanction order also.
Yes.
Where is the petition? If you have raised, you might have filed any petition. Where is the
In the order itself, it is reflected.
At the time of framing charge, most probably they have filed a petition for
Yes.
discharge and all.
And
during that period, they have some materials were brought.
Even
Don't I consider the order was the lengthy order, it was passed by the learned trial.
I relied on the judgment.
Okay, heard Mr. B. Chetri, the learned counsel for the petition, and also heard Mr. M. Halil, the learned standing counsel.
Judgments have been relied to.
Stop. This is an application by the name of so and so. Next
No
petition of Mr. Chetty, the counsel for the petition submitted in this paper, that the prosecution without any proper investigation has filed the charge sheet against the present petitioner without even considering his expenditure statement and the property which he acquired during the period of his service. Stop further, he submitted that the FIR was lost considering the check period from 1/1/2013 till 31/12/2019, and without considering the period of his service from which he entered. Mr. Chetty further submitted that the sanction order was also issued without any application of fine. Especially, he emphasized on para 3 of the sanction order, wherein it was stated that the competent authority under section 19(1)(a) of PC Act 1988 is decided to remove the present petitioner from service after careful consideration of the material, etc. Wherein the petitioner was not in service at the time of filing of the FIR vis-a-vis the time of procuring the sanction order. Mr. Chetty further submitted that the statement brought by the CBI is totally wrong and incorrect statement. And he also produced the correct statement along with the petition, which was calculated by a competent person, that is by chartered accountant. Accordingly, he submitted that the prosecution sanction as well as the cognizance order vis-a-vis the charge frame against the accused petitioner is liable to be set aside and quashed. Next para, Mr. Holloway submitted in this regards that there is no wrong in order of sanction passed by the competent authority. Rather, for a retired person, the sanction is not at all required. Further, he submitted that for a CBI, one check period has to be considered to calculate the assets of any particular persons, and after assessing his disproportionate property only, the CBI had lost the FIR during investigation only the entire the assets and liabilities of this so and so and disproportionate amount of the property only during the investigation, the charge sheet was filed along the so and so. Mr. Halil further submitted that this is not even a case for issuance of notice to the respondent, and the petitioner may take those pleas at the time of the hearing or evidence, and accordingly paid for dismissal of the present petition instantly. Next para. Considering the entire submission made by so and so, this court is of opinion that notice is to be for the allow this hearing so and so notice is notice is to. Now you are representing one, two, all.
1, 2, no, 3 and 4, 4. 3 is different, railway.
3 is railway, na? So 1, 2, 4.
1, 2, 4.
1 to 4 আছে 3 copy notice করে দিব and requisite copy করে দিব and also call for the scan copy of the LCM.
One more submission. We may be allowed to file a written objection.
Further, considering the submission made by Mr. Halloy, the respondent is also allowed to file the written objection in his list accordingly when it can be. January any date. Which is the next date fixed in your case?
It's 4th of January.
4th of January.
So meanwhile, my lord, this special case may be stayed.
No, I have objection. No stay.
Stay the proceeding.
No stay.
Otherwise, my lord, the whole purpose of coming before lordship would be in. To
No stay because there's a clear lordship, if your lordship see the PC Act lordship for irregularities committed for sanction lordship, no stay lordship.
now, whatever it is, we'll
Yes.
show it, we'll argue it, and when the lordship will pass the final order, that will be heard by your lordships and pass the order. But till then, my lord, at least this parallel proceeding cannot go together, my lord. Since lordship has considered that aspect, my lord, and I have a case, my lord, a prima facie case, my lord.
Then
And
Yeah.
in the hearing, lordship will decide. Whatever
we're
it is.
fixing it on 10th of January.
Highly objection.
On 4th, you can pray even time. Stay cannot be there. It's a case of CBI. Should not be there.
No, lordship, no, since then priority, because court. my lord-
Prior 4, you want?
Yes, prior for my lord. Otherwise,
Prior 4 can be given. Then it will be our vacation will start from.
no, prior,
End of the-
no, end of the vacation is 22nd. Prior for means 4th of January, before that, my lord.
Third.
Third or second, my lord.
Third is?
There is no stay available.
It may not be possible. Our office is reopening on 3rd, in fact. Office is reopening on
Because
3rd.
there is no stay order. Let it be on 10 lordship. Let him argue on 10 and he can make out any case
No,
lordship.
no,
It will be
since,
quashed.
no, my lord, since the matter is pending before the court below, my lord.
Now see,
And-
next day, most probably it is fixed for evidence only. You can pray for an adjournment on that
Yes,
day.
No,
Definitely it will be allowed because otherwise the 10th, it matter may be heard and decided. Otherwise, what will happen 3rd is just opening day.
Correct. lordship.
May not be possible.
Correct.
And till 2nd, it is holiday. So prior to that, if you want, then 17, 18 or 19, something like that, can it be
Let it
possible
come
on your part?
Lordship. Yes.
If you can submit your written objection by 10th or, no, sorry, by before vacation.
For vacation lordship, we need to get lordship from various table and various office it has to go. That is the difficulty.
Okay, let it be in 10th of January.
10th
We'll decide it later.
10th of-
Finally decide. Yes, 10th of January.
Highly
My
objection.
lord, since no 10th of January, I thought that the 10th of December. My lord, some.
No, it's up to Halo. If he can manage to file the written objection prior vacation, then we'll try our best.
Lordship quite
No,
impossible because birth sex cases are there lordship. 41.
No, that-
and then this is an extra effort lordship and this I mean to say written objection or needs time lordship. For vetting and all.
Nah,
at least
otherwise,
we've got good-
again,
Now, one thing I must say that Mr. Halway is working in under pressure. I think most probably there are several matter has been fixed this
that
things,
is why, my
this
lord,
act under this act.
since till then, my lord. Lordship will
Yeah.
consider till then, this stay may be granted. Otherwise,
Stay-
otherwise, my lord, the whole purpose, again, my problem and his problem, my lord, it will go on, my lord,
In one.
before this honorable.
One day.
And because he is already overburdened.
Finish it.
I know, my lord, he is already overburdened, my lord.
Lordship notice. is
So,
not
my lord,
provided, your
at
lordship
least-
has decided lordship to be issued.
At
notice.
least, my lord, I should not be suffered for this, my lord.
Will not suffer lordship.
Since lordship will decide the matter on whatever the written objection, whatever it comes. But till then lordship will
Stay
consider
cannot.
that aspect because there is
At
time.
best, I can give you, you can try. I just
Lord,
rather I
Lord.
try for vacation or what কোন গিটা date আছে? I think মানে workout of যাবতো লাগিব। Our vacation starts from when?
20th. On 20th.
23rd.
Last court will be on 20 December.
20 December order me because
And-
my
No, not possible.
they are from Arunachal
Before
because
that,
they will
before that, my lord,
will not
20
be
December
possible.
again, there
20
will
December
be
maybe.
hectic time, my lord. That is why, my lord, can it be on December, this 10, 12 or, my lord, like this?
17 can be. We are listing it on 17. You try just.
Yes.
17. Oh, 17 December. If it is
Lord,
possible, you just try. 17th of December.
Lordship has observed that on that day.
No, now see, this is a severe case of severe. I just don't want to pass any order on stay. We'll try to dispose of the matter rather, but stay may not be possible on 17/12.
Lordship. Highly.
Yes, right. Yes, there are just after this one. Most of them they have scam accounts. Scam. So 33 is the petition. 33, I mean, no.
Lordship fixing the date on 17th as my lord. As no on 17th as motion day. As motion or Lord.
Already 10 hearing matters already been fixed. Fifth may not be possible. Your piece of paper. 2020 matters, can it be after 2 weeks? After 2 weeks?
They are insisting on the matter for, and it is very small matter, my lord. It may not take much time because.
10th, 12. 12, 12. 12.
Upgraded item 33 for real hearing.
Lordship, for time being, Lordship, let my senior counsel argue. For time being, I just want to give one instruction in court number 20. I mean to say just.
Then again, for your reply, will there be any
Let him continue, Lordship. I think he'll take some time. I'll bring this matter.
time in the sense I have, by the way, how are you now? It's okay now.
fine, it's
Now
okay.
you're fine.
Sorry.
Anyway, then submission already made by Mr. Bora has already been recorded.
Lordship.
Only one point you are to submit that
Yes.
regarding the section 33
Yes.
notice. That was the main issue.
Correct.
And on the last occasion, it was pointed out that though notice was dated of October or something like that, but it was
In the month of
notified or
November.
it is in the month of November. That was the submission.
Lordship.
So apart from that, Mr. Bora, if you have any submission, other kindly.
Only two issues. One, my lord,
Lordship, I'm taking your.
one that,
Okay.
one that lordship has already probably, my lord, marked it. That is regarding that without disposing of my remand petition, my lord, pending in the CBI court,
Yes.
they have taken the remand from the session judge, my
Yes.
lord.
Session does a Teshpur.
Teshpur, who doesn't have the requisite jurisdiction at that point of time, my lord. So this petition was pending. In spite of that, they went to the Shonitpur and took my remand, my lord. So that from that remand itself is illegal. So subsequent all remand is automatically become illegal, my lord. So I am on illegal detention. That is the one issue. That's a very serious issue. And in my second contention, my lord, the lordship kindly take up, my lord, that IT Act, my lord, Information Technology Act. Section 8, my lord, Information Technology Act 2000.
Section 8, my lord. Regarding the publication of the notification, my lord. Where any law provides that any rule, regulation, order, bylaw, notification, or any other matter shall be published in the official gazette, then such requirement shall be deemed to have been satisfied if such rule, regulation, order, bylaw, notification, or any other matter is published in the official gazette or electronic gazette. Provided that where any rule, regulation, order, bylaw, notification, or any other matter is published in the official gazette or electronic gazette, the date of publication shall be deemed to be the date of the official of the gazette which was first published in any form. So date of publication in the official gazette should be reckoned as a publication. So effective publication will be counted only from the date of publication, as per this Information Technology Act. Now, in the BNSs also, my lord, new BNSs Act also, the notification has been defined, my lord. The two 2P, my lord, in the BNSs, my lord. The notification has been specifically defined.
Two P,
my lord. O is the non-cognizable offense. Next one is the P, my lord. OP.
Yes.
Notification means a notification published in the official gazette. Published. It has to be published in the official gazette. Then only it can be taken as a notification. So as per section 3 of the Delhi Police Establishment Act, there has to be a notification published in the official gazette. Then only it can be taken into account. Now, Lordship, kindly see here, I have given a note, my lord, kindly, Lordship, kindly take up the annexes, page 3. Page information bureau. Lordship, kindly see page annexure 3, my lord, appendix A, my lord. Press Information Bureau, my lord, Government of India, Ministry of Law and Justice. The Gazette notification of Government of India will henceforth only be e-published as they are uploaded on the gazette.nic.in. So from 29 October 2015, my lord, you can see it. So there is a mandate by the Government of India that all notification has to be e-published and uploaded in the gazette. So in the next page, Lordship, also kindly see page 4. It has been decided to switch the exclusive e-publishing of the all gazette notification of Government of India 1st of October 2015. It has been decided that the physical printing and the sale of the hard copies of the gazette by the completely ceased. So there is no hard copy. This matter is in the line of provisions of section 8 of the Information Technology Act, which I have already placed, my lord. The Gazette of India will now be only e-published by uploading on the official website. So from 2015, there is only a e-publication regarding the official gazette. And as per the mandate of section 8, when it is published on that day, it should be reckoned as a publication. And on that day itself, that notification will come into the force on the date of publication, not prior to that one. So that has been settled. Now, Lordship, kindly see my friend has placed the notification on the last occasion. This is 6, my lord, page 6, annexure B, appendix 3, my lord. Now, this is New Delhi, October 20 to October 26. This is the issue period, actually, weekly issue period. Notification has been issued, but was not published, my lord. This is the issue period. It is not publication date, my lord. I'll come to that, how it is come to now. Lordship kindly see, there are several notification of various department. Various issue dates are there. Some notification of the financial service, Lordship can see. Then there are various different notification. These are the issue period, and our notification comes to the internal page 10, my lord. Ministry of Personnel, Public Grievances and Pension, Department of Personnel Training, that is New Delhi, on 18 June. So this is in now last page of this, my lord, notification. Lordship kindly see page 12. The last portion of the page 12, Lordship can see. So I have magnified in the next page also the last portion. The Gorakhnath Yadav. It was digitally signed by Gorakhnath Yadav, that is on 11/6. So 6th of November, my. So Lordship probably seen that person. The last portion I have magnified also in the next page. And in next page, my lord. Now in the official site of the Gazette of India, that is page 14, the last serial number, Lordship kindly take up, the serial number 20. Now Lordship kindly see, there are certain column in that particular Gazette of India. The column includes department, office, subject, part and section, then issue dates. Issue dates, publish dates, Gazette ID and download. So now Lordship kindly see the serial number 20 in the column issue date. Lordship will find issue date is 26th of October 2024. So here also the Lordship again kindly take up the page 6. Page 6, it will tell you the issue dates. So as my learned friend is trying that it was published on 26, my lord. It is October 26. That is this is an issue date. This is October 20 to 26. So Lordship will find in the official Gazette issue date, it is 26 October, which is tallies with the Appendix B, page 6, my lord. Same ID, my lord. ID is the same. So now Lordship kindly see the published date. Published date is 6th of November, my lord. And it also tallies with the digital signature of Yadav, my lord, that it is on 6th of November. Gorakhnath Yadav signature tallies with the official Gazette date of publication, my lord. So it is apparent on the face of the record, my lord, that it was this Gazette notification was published on 6th of November. So from 6th of November, this notification under section 3 came to the force, not prior to that. So any action taken prior to the 6th of November is non-est in the eye of law. Because at that time, CBI did not have the requisite power, jurisdiction to take up the investigation prior to the 6th of November. So whatever they did, the taking up the investigation, filing the petition, adding the sections, remanding the accused to the custody, these are absolutely in violation of the section 3 of the Delhi Police Establishment Act. Section 3 and 5 is very clear, my lord. They will, first of all, it has to be notified in section 3, as per section 3, gazette notification. Then they will have the requisite power to investigate the offences. Section 5 says that if they have the power to require, then they can enter into the various states, extension of the jurisdiction, because otherwise the jurisdiction is limited to Delhi only and the union territories. So the section 5 notification is required. Section 6 notification is the state government has to hand over because it's a state subject matter. So that's not how we are not disputing they have handed over, not. They have rightly handed over, that's not disputed. Section 5 is also not disputed. Only dispute is that they have given it to the CBI, but at that time, CBI did not have the requisite jurisdiction to investigate. They have assumed that jurisdiction, but without the power. So a jurisdiction cannot be, my lord. So section 3 is very clear. Now that I am relying on one of the Supreme Court judgment, my lord. This Supreme Court judgment 2009 SCC, my lord.
Yes.
3-bench judgment, my lord, paragraph 17 regarding the notification, my lord. Whether the publication and from which date it can be reckoned as effective, my lord. Earlier, there is dispute regarding the publication, but the same matter subsequently referred to the larger bench, and this is the larger bench observation, paragraph 17, my lord. From the aforesaid observation, it is plain and clear that the decision in BK Srinivasan also reiterates that the notification will take effect only when it is published through the customary recognized official channel, namely official gazette. So here also section 3 specifically mandates that it has to be published in the official gazette. Notification in the official gazette. We also agree with the reasons recorded in Mayor's George and hold that the notification under section 25 of the Customs Act would come into operation as soon as it is published in the official gazette and no further publication is required. Hence, the decision of this so is this one. So the first 3 lines is very clear, my lord, that to give an effect, the customary requirement is that it has to be published in the official gazette. So that has been 2020. Page paragraph 20. So there's a one, I have already relied, my lord, 2020.
One more is there.
Paragraph 20. It has clearly stated that the 3 various stages, how the CBI can take up the investigation, my lord. It's not automatic. First requirement is that first requirement, my lord, paragraph 20, that a notification must be issued by the central government specifying the offences to be investigated by the Delhi Police Establishment under section 3. One judgment, 2020.
Yes, 2020, na?
Yes,
20.
paragraph 20, my lord. So there are 3 stages, my lord. The first requirement is that this is a mandatory, my lord, that the notification has to be published, my lord. So this is my submission, my lord, that the first of all, without the jurisdiction, Punitpur has remanded me. In spite of the petition is not without being disposed of. This is a very serious consequence, my lord. The magistrate has specifically said the petition should be kept on record without disposing it. In spite of that, they went to the session judge, took me into the custody, which is, and the session just prior to that, already there is a notification by our High Court that all cases has been transferred to the CBI and jurisdiction has been assigned to the CBI court itself. In spite of knowing fully well that the jurisdiction has been assigned to the CBI court in Guwahati just to satisfy their needs to take me into custody. They want to buy hook and crook, my lord. They want me the custody. Let it be in violation of the law. They want my custody. So in violation of the law, knowing it also, my lord, that the jurisdiction has been already been given to the CBI court. Then why they have went to the session judge in Sunitpur? They can only went for the Sunitpur session judge for the transit remand because he is in the custody of the Sunitpur remand. That this man is required to produce in the so-and-so. That best that they can do, not take my custody, my lord. Custody will be given by the special court here. How the session judge can operate it. Now, and the order sheet also reveals that the petition, their old petition for seeking the custody was pending at the time. I have already placed in the order of the magistrate, the session CBI, specific the point number 6. The IO has filed a petition under section so-and-so, BNS's police custody of the Hemen Rava and Shankar Shah. At this stage, as these accused is yet to be produced before the court, as such, no order can be passed at this stage. Only on production of this accused, prayer of the IO will be considered. Let the petition be kept in the record. So without disposal of this case, my lord, this petition, they went to the session judge, took my custody in violation of all the procedure, my lord. This is how the CBI is operating, my lord. My the right and liberty, how they have taken into my lord, is apparent. Absolutely violation, my lord. It is liable to be compensated, my lord, not only the bail, my lord. This is absolutely violation of my personal liberty, my lord. How they can do it, and that to a court who doesn't have the jurisdiction, just because he is in the custody of that particular district, my lord. And record is here. On the same day, you file here one petition, you file in the same petition, my lord. I have never seen this kind of, my lord, act by investigating it before, my lord. I'm very sorry, very upset, my lord, to be precisely, my lord. We have never seen, never expect, my lord, also. So these are my submission, my lord. They don't have the jurisdiction. Now may have the jurisdiction, but they at that relevant point, when they took up the investigation, when they take up the custody, heading section, all has gone, my lord. Because at that relevant point of time, there's no notification as far as me. There's no publication at all, my lord. That's all. And today I'm in 83 days in custody.
Right, Lordship, we have filed a written argument of yesterday, Lordship, it is on record, I think.
No, I have not given the copy, my lord.
With the scan of the petition, there is no notification. And though there was a notification, it has been published in the month of November. Also, it is a record, it is on record, Lordship. You also will find, yes, Lordship, after going through the record, it reveals whether it was published in November or October. It is there only, Lordship. Regarding the authenticity, Lordship can find it by your Lordship in the official website. On that, we have nothing to say. Now, Lordship, whether prior to this, whether there is notification under section 3 of the DSP Act or not, there is to be looked into. Lordship may kindly have a look in page 10 of my written argument. Page 10. Annexure 4. Annexure 4, Lordship. It was, this is an official gazette notification just published on July 2024. Lordship. This is clear. Just published in July 2024. And what is the publication, Lordship? Your Lordship will find in page number 11, Lordship. Prior to that, Lordship, I would like to make a submission, Lordship. I'm sure, Lordship, that petitioner will not, Lordship, dispute the fact that CBI had jurisdiction under Section 3. Already those offences already been notified earlier, as because cases are pending before the CBI court as well as in High Court with regard to the IPC offence. So on that point, I don't think we can make any objection to it, Lordship. So earlier, prior to this present notification, here exists a notification, gazette notification under Section 3 of the DSP Act, prior to publication of the present notification. Clear, Lordship?
Prior to publication
of this notification, 26 November, October.
October.
Yes. I do that, Lordship, because CBI is investigating offence under IPC. Definitely there had to be a notification, gazette notification to the effect. And on the strength of that gazette notification, CBI is investigating those offences under IPC, Lordship. Subsequently, after the coming into force of the BNS, Lordship, this notification has been published. It is a gazette notification. Lordship will kindly come to page 11, Lordship.
So this annexure
Annexure
4.
4, page 11.
No, no.
Starts from page
Annexure
10.
4.
Yes.
Annexure 4 is, you want to say that this one is the
Gazette notification. Was published in July 2024. Did the Lordship got it? In the
Yes.
first page. Lordship may now kindly come to the next page, page 11, Lordship. Page 11.
Yes.
Now we kindly come to the reference first, SO 2790E. SO 2097E.
Yes.
Ministry of Law and Justice. This is the standing order. This has been published in the official gazette. Let us read, Lordship, what this SO says. In pursuance of Section 8 of General Clauses Act, the central government hereby notifies that where any reference of the Indian Penal Code or Code of Criminal Procedure or of Evidence Act or any provision thereof is made in any act of Parliament, act made by legislature of any state, ordinance, regulation made under Article 240 of the Constitution, President's order, rules, regulation, or order or notification made under any act, ordinance, or regulation. I am sticking to this F. I am sticking, Lordship, my submission respect to submission, Lordship, F. F specifically says that if there is any reference to Indian Penal Code or any provision thereof, or any notification under the Act, here the Act we are referring to is the DSP Act. For the time being in force, such reference shall be respectively be read as reference to BNS, Bharatiya Sanhita, so and so, the Bharatiya Nagarik Suraksha Sanhita, or the Bharatiya Suraksha Adhiniam. So from this notification is clear that if any reference is made under IPC by any act, here the act which has been referred is DSP Act. We are referring to as DSP Act, Lordship. So if any reference is to be made under the Indian Penal Code, Lordship, it has to be read as BNS, Lordship. So this notification has already been published in the month of July, Lordship. 15 July, and there is a gazette notification. Subsequently, Lordship, this notification particularly specifying the offences under the DN. So there exists the notification, Lordship, prior to the notification under Section 5 and Section 6 of the DSP Act, Lordship. So, my respectful submission, Lordship, already there is a notification and power has been given to DSP, I mean to say CBI, under Section 3 of the DSP Act to investigate the offence under IPC, which has to be construed as BNS, Lordship, by notification 16 July 2024. That's my submission with regard to stand taken by the petitioner, Lordship. Thereafter, several other notifications has been published Already those facts has been placed before this honorable court. I will not reiterate it. With regard to section 5 and section 6. That's here. And now with regard to the stand taken by the petitioner that there is a violation of section 187, that is 167 of the CRPC. What my learned friend, senior counsel for the petitioner has stated that we have violated. Lordship may kindly have a look into the 187.3. Let us read 187 also.
BNSS.
BNSS. What their respectful submission is that, Lordship, the accused should have been produced before the magistrate at the time of taking custody. Lordship, the accused was not in our custody when we moved the petition before the learned session judge, who is a designated court, Lordship.
Not a designated court.
It is a designated court, Lordship. I
Already notified.
No, yes, correct. Notified, but jurisdiction is still there, Lordship. I've made my annexure. And all the records pertaining to that case is in the custody of that court only. Lordship may kindly have a look into, before going to the provision of 187, Lordship may kindly have my written argument for him. Page 14. Page 14, Annex 7. This is the notification of Guwahati High Court, Lordship, whereby a designated court has been constituted. Page 12, Lordship. May kindly come to page 12 of my written argument, Lordship. Annex 5.
Yes.
On, your Lordship, what is page number 12? It is a notification of the Judicial Department, Government of Assam, Lordship.
Page 10 or your
Page 12. Page 12 of my written argument.
Acha.
With your Lordship, what? It is a Government of Assam Judicial Department, Judicial Branch order by the government. It's a notification which was issued on 21st of January 2021. May I read, Lordship? On the recommendation of the Honorable Guwahati High Court, communicated by the Registrar General Guwahati High Court by notification number 25/11/2020, the Governor of Assam is pleased to designate the Court of District and Session Judge in its district of the Assam as a designated court under the banning of unregulated scheme. So, by virtue of this notification, all the district courts is having jurisdiction to try cases under the banning of unregulated deposits. So, in view of this notification, the court below, Learned Session Judge Sonitpur, has got the jurisdiction. We have applied for taking custody of the accused. Subsequently, on 2/11/2024, Learned Session Judge Sonitpur had passed the order whereby we have taken custody of the accused, and thereafter, before as per the direction of the court, Sonitpur court, Lordship, we have produced the accused before the designated court CBI. So there is no irregularity. Lordship may kindly have a look now to the provision of this BNS Act, Lordship. There is 187 of the BNS. Whenever any person is arrested and detained in custody, and it appears that the investigation could not be completed within the period of 24 hours fixed by section 58, and there are grounds for believing that the accusation or information is well founded, the officer in charge of the police station or the police officer making the investigation, if he is not below the rank of a sub-inspector, shall forthwith transmit to the nearest magistrate or a copy of the entries in the diary, hearing after referred, specified relating to the case, and shall at the time forward the accused to the magistrate. Subsection 2. The magistrate to whom an accused person is forwarded under this section may, irrespective of whether he has or has jurisdiction to try the case, after taking into consideration whether such person has not been released on bail or his bail has been cancelled, authorize from time to time detention of the accused in such custody. The language is such custody, Lordship. As such magistrate thinks fit for a term not exceeding 15 days. So the maximum period of detention in his custody is 15 days in the whole or in part. So this 15-day custody to police can be given in a whole or it can be given in part. In this case, initially when the Assam police has taken custody of this accused person, he was taken into custody, given custody for 2 days. Thereafter, again, he was produced before the designated court, Sonitpur Lordship. Again, it was subsequently extended for another 3 days. And thereafter, the Sonitpur court has sent the remanded back the accused person to judicial custody. So at the time when we moved the petition, the accused was in the custody of the Honorable Sonitpur court. He is not in our custody. So the question of bringing the accused to the learned Sonitpur court doesn't arise, Lordship, as per provision of 187, Lordship. Thereafter, Lordship, may kindly come to subsection 3, Lordship. The magistrate may authorize the detention of accused person beyond the period of 15 days if he is satisfied that adequate ground exists for doing so, but no magistrate shall authorize the person in the custody, so that this is the 90 days and 60 days period. And finally, Lordship, what my counsel for the petitioner is saying that he should be in custody, Lordship. Lordship, it's very clear from the reading of subsection 4 only, Lordship. No magistrate shall authorize detention of the accused in custody of the police under this section unless the accused is produced before him in person for the first time and subsequently every time till the accused remain in the custody of the police. So at the time when we produce the accused, when we move the petition before the learned session judge Sonitpur, the accused was not in our custody, Lordship. So this section is applicable only when the accused was in custody of the police, Lordship. So therefore the stand is not, Lordship, attracted. Therefore, there is no lacuna or, Lordship, infirmity or irregularity on the part of EDI to take custody of the accused person, Lordship. And accordingly, after passing of the order, we took custody of the accused, and on 4th, that is prior to expiry of 60 days, Lordship, we produced him before the designated court as per the direction of the Sonitpur court, Lordship. And thereafter, he's been again sent back to the judicial question. So the second point also has no, Lordship, legs to stand, Lordship, and therefore, the offense, Lordship, will have to see, Lordship. It's a very grave economic offense, Lordship. The Lordship sees the material, Lordship. The Lordship will find, Lordship, large number of person has deposited money in his personal account, which has subsequently been converted for his own use by procuring property and all, Lordship. The lease has been annexed, Lordship, for the property he has procured during this period, Lordship. And therefore, at this stage, Lordship, I am praying before this honorable court not to grant bail. That's my expectation.
I'm just, because I got this just now, my lord, I'm just replying to my lord. My lord, this is absolutely, my lord, this notification is no use here. The notification he relied on. If this notification already exists, why there is a subsequent notification, my lord? First of all, now, Lordship, kindly take up this annexure 4 once again, my lord. What is this, my lord? Lordship, kindly see this notification. This notification is not under section 3 of the DSP Act, man. First of all.
Annexure 4.
Annexure 4, my lord. This notification is very clear. It is not under section 3 of the DSP Act, man. What is this notification, my lord? This is in section 8 General Procedure Act notification, my lord. And what it speaks, my lord, that if there is something is required to be raised under IPC, if there any reference is made in IPC, my lord, it can be taken as a BNS. That is the notification, my lord. That is already there. There is no need for that. General Procedure Act is very clear, my lord. And BNS is also very clear in this repeal and saving provisions, my lord. This notification, what it says, my lord, in pursuance of the section 8 of the General Clause Act, is not under section 3 of the DSP Act, my lord. First of all, the requirement is that the official gazette has to be under section 3 of the DSP Act, my lord. That is the requirement. Supreme Court also clarified. Now they are taking the advantage of this notification. But what is this notification all about, my lord? This notification says if there is any reference regarding the IPC offences, it should be read as in BNSS. That is the let us read if I am wrong, my lord. In pursuant to section 8 of the General Clauses Act, the central government hereby notified that where any reference of Indian Penal Code or Code of Criminal Procedure or Indian Evidence Act or any other provisions is made, then F, rules, regulation, order, or notification made under Act, ordinance, regulation. For the such time being in force, reference shall respectively be read as reference of Bharatiya Naitya Samhita. So, if there is any reference to the IPC, it will be automatically read, can be read as a reference of BNSs. We are not disputing that. But there has to be, first of all, there has to be some reference of IPC. But their whole case, like you can see, their case is registered not on IPC, my lord. Their case is registered under BNSs. Where is the question of the reference of IPC here comes from? I am flabbergasted, my lord, by this argument, by the way. How there is reference of IPC, my lord? The case has been registered under BNSs. How now can you say that no, there's a reference of IPC, so I'll take it as a BNS. There has to be some reference of IPC. Then you can take it as no, this is BNS. Had they have registered the case under IPC, I can understand that. That yes, case has been registered IPC, so they have already there is a notification existed by the CBI that the CBI can investigate the IPC offences. So under the General Clauses Act, this is continuous. That can be read as BNS. Absolutely, no problem on that. But here, case is not registered in the IPC. Where the reference comes from, and the whole, this gazette notification, which they are relying on, this is not under section 3 of the DSP Act, it is under section 8 of the General Clauses Act, If this notification exists, then why the requirement of the subsequent notification under section 3, which has been published in November 6, So this notification, it does not relate to these cases, Absolutely no, Then, the second part, my limited understanding of the 187, which is earlier 167, the first time any magistrate can, the nearest magistrate can authorize for detention. There is no dispute on that. We have to read all the reference, all the provisions together, not the part, second part. Lordship kindly see the 187, what it says, First time, yes, the magistrate is authorized for detention. The nearest magistrate. Not the second and the third, if he doesn't have the jurisdiction at all. First time, because, Lordship kindly see, let us read it again, I may be wrong, I don't know, My understanding of the law, very limited. But what I have gathered so many years, that the first time the magistrate, either executive or in the judicial also, even the executive magistrate is empowered for the first time, not by the subsequent, If this argument is accepted, then the magistrate, that means that the executive magistrate are also empowered to remand the person. Is it the law, Absolutely no, The first time, whenever, the first line is very important. Whenever any person is arrested and detention is custody, and it appears that the investigation cannot be completed within the period of 24 hours. That means the first remand period, when it cannot be completed within 24 hours, then he will be placed before the nearest magistrate. And then the nearest magistrate is authorized for the detention also. but not the subsequent one which doesn't have the jurisdiction. Then you have to bring it to the nearest magistrate, my lord. And the grounds for the believing that the accusation and the information is well founded, the officer in charge of the police station, police officer making the investigation, if he is not below the rank of the sub-inspector, shall forthwith transmit it to the nearest magistrate, my lord. This has to be nearest magistrate. It may be an executive magistrate also. Copy of the entries in the diary hereinafter specified relating to the case and shall at the same time forward the accused to such magistrate. So it is maybe the nearest magistrate. So if the investigation is not completed within 24 hours, then this is applicable. Now now the magistrate to whom the accused person is forwarded under this section, that means the under 187(1), may, irrespective of whether he has the jurisdiction or not, that means the first magistrate, he may not have the jurisdiction to try, but he has the power to remand the accused. That is my understanding of the law, man. But the subsequent remand has to be, my lord, before the concerned Eleka magistrate. It has to be. They cannot bypass that, my lord. This is the mandate of the CRPC, my lord. Now what they are doing, my lord? The first remand was there before the magistrate. All the subsequent remand is there by the session judge of the Punitpur, because at that time matter was not separated to the CBI. It was not given to the CPI. So he had the jurisdiction at the time. That I can understand, my lord. But now they are taking the advantage of the section 2. But the section 2 is always related to the section 1, subsection 1, my lord. Within 24 hours, my lord. Only if within 24 hours he can remand as many as time, my lord, up to the 14 days custody, my lord, without having the jurisdiction also. But subsequently he doesn't have the power under 187. That's very clear, my lord. Now, and the session judge also reflected, my lord, that he doesn't have the power on that day because there is already a high court notification. So if there is a high court notification prior to that, which sees the power of the session judge, why they have filed the petition before the session judge in spite of these notifications? Because they don't have the remand, because at that time he is not under their custody. What does the custody means, my lord? Custody doesn't mean that they are physical custody, my lord. They have the cases already handed when it is handed over. The custody will be determined by the court. The court will give the police custody for a time being. The competent court. They are saying we didn't have the custody. What does it mean, my lord? You need the custody. You are already given the case, already cases endeavored to you, my lord. You are not taking the investigation. You have to follow the procedure. Just because you don't have the physical custody, it was remanded by the earlier investigating authority, it doesn't mean that you have lost the custody, my lord. You need the custody for further remand. You have to place it before the court, competent court, accused. And they have also placed their petition also before this court. It's not that. Why they have filed the 2 petitioner, that I couldn't understand. If they are saying that we didn't have the custody, so I have filed a petition there. We should have stick to that principle itself. Then why you have filed a petition here also? For seeking the custody here also? What is this principle, my lord? We are playing with the courts, my lord. Because this court has rejected, so immediately you went there, filed a petition, took by remand, which doesn't have the jurisdiction at all. That's all, man.
My lord, in reply to only on specific submission made by learned counsel for the petitioner, I am again reiterating taking your lordship to the notification, gadget notification, lordship, page 11, lordship. Lordship, section 3 notification with regard to IPC offences were already there. That is not, I don't think my learned friend will dispute on that. This is apparently correct, lordship. It's a notification under section 8. But what this notification speaks, lordship? This notification speaks, lordship, if there is any reference to IPC evidence for CRPC, lordship, it has to be construed with regard to BNS, BNSS, and Lordship, the Evidence Act, Lordship. That it means
No, but the submission of Mr. Bora is that
That there is no
that
section
is
three
already, the case was registered only on BNS and
Correct.
BNS.
correct. It was registered, but the offences, Lordship. I'll place one judgment of this Honorable Court, Lordship. Division Bench of Honorable Guwahati High Court, it says, Lordship, if Lordship, it is a settled law, Lordship, that criminal law cannot be given a retrospective effect, Lordship. If some act has been enacted today, Lordship, it cannot be taken to Lordship.
It's obvious.
That is settled law. Otherwise, it will be a violation of Article 20 of the Constitution. No person can be convicted of an offence for an offence which is not in existence, Lordship. So, Lordship, this notification clearly speaks, as because earlier there is a notification which empowers the CBI to investigate the case under Section 3 already exists. As because, Lordship, it's a state machinery, Lordship. Cannot be, Lordship, immediately after Lordship enactment of a act, Lordship, it will immediately go to a notification. It's not like that, Lordship. It will take some time. It's a procedure, Lordship. So therefore, first initially this notification has been published, Lordship. Initially this notice has been published, and which speaks about that if any offences under IPC has been committed by anyone, it has to be construed as BNS, Lordship. Because Section 3 notification under DSP is already there, empowering CBI to investigate, Lordship. And this notification speaks about that only, Lordship. This notification speaks about the power of CBI to investigate offences under Section 3 of the DSP.
Is it there?
No, it's not specifically there. But what does this mean, Lordship? Lordship, may kindly read once again, Lordship. It is under Section 8 of General Clauses Act.
Yes.
Act may kindly once again, Lord. Let us read once again. The central government hereby notifies that where any reference to Indian Penal Code, if there is any reference to Indian Penal Code, Code of Criminal Procedure or Evidence Act, or any provision thereof is made in any Lordship act made by Parliament, let it be BNS. If in BNS, Lordship, if there is a reference of IPC open, it has to be read as BNS, Lordship. Act made by legislature, ordinance, regulations under Article 240 of the Constitution, President's order, then this is what we are relying on, Lordship. F, rules, regulation, order, or notification. So what I want to submit before this Honorable, already there is a notification under Section 3 of DSPA, which empowers CBI to investigate the offence under IPC, Lordship.
But this is not IPC, that is my point.
That what has been clarified. That
No,
what
no.
has been clarified. Let us read. For the time being in force, such reference shall there respectively be read as reference to BNS. If any offence has been committed under IPC, that has to be read as BNS. That is what my little understanding on the reading of this.
Then page 10, my lord, then if that be so, my lord, why the second notification is required?
Second, yes.
The page 10, he is on the page 10 of my lord. They have given it that the 18 June notification is, why requirement is that, my lord?
That has
If
been,
there is an existence of the notification itself by virtue of the General Clauses Act, why the second notification is required under Section 3 of the Act, my lord, DSP Act? If this notification itself covering the Section 3 of the DSP Act itself, the reference will be automatic. Then why the second notification is required under Section 3? Because it doesn't say about the Section 3 requirement. It is only if there is a reference. First of all, there has to be a reference of IPC, CRPC, or Evidence Act. Then only it can be. But here there is no reference at all. You have to register the case under BNSs. BNS, my lord. Procedural will be BNSs or Evidence Act. Then only it can be read. So if they have registered the case under the IPC, yes, we can understand it can be taken as a BNSs. That is the General Clauses Act. But the General Clauses Act does not give the power to override the section 3, which is under otherwise mandatory under the DSPM. So that is why subsequently they have gone for the second notification under the section 3. Otherwise, what is the requirement of the secondary? This is the contradictory stand by the CBI itself. One way they are saying that this notification is sufficient to take up the investigation because there is the IPC offense is already given to the CBI by the all previous earlier notification. So by section 8, we are empowered to take up the investigation under the BNS. Then what is the requirement of the second notification, which has been published in the November? You made an issue date on in the June. What is the requirement of publication if it is so automatic manner? Because that notification on the General Closure Act, it does not satisfy the requirement of section 3 notification, because section 3 notification is mandatory in nature. It has to empower, give the jurisdiction to the CBI to investigate the specific offenses under the scheduled manner. That is the section 3. That's all, man. I'll leave it to your lordship.
Number of. It may not be possible this one.
Really?
Opening to select. Multi-delay.
Engaging counsel, you see that at all, but you will give them.
I'll try my best to
Tomorrow,
by tomorrow.
tomorrow,
I'll try. Today may not be possible.
tomorrow at 2 o'clock, my lord, you can fix it for the hour. If possible. If possible, I'll leave it to you, lordship. Highly obliged, my lord.
Lordship, one more judgment, Lordship, may kindly, 2013 7 SCC. 2013 7 SCC, page 450, Lordship. YS Jagan.
2013 7 SCC
450, Lordship.
450.
450.
And
This,
para?
Lordship, para 34, Lordship. Para 34 onward. 34 and 35. That is YS Jagan Mohan Reddy versus CBI, Lordship. With regard to economic offense, Lordship.
I'm not on the,
No, correct. I'm
not hampering on the, otherwise also I can place the other, all the other accused matters I have appeared today has been granted bail. By the coordinate court, the same offenses. Obliged, my lord.
Highly obliged.
Highly obliged.
Into রাখো কাম করবো না কোনো কোনো objection ছিল না shit একটা দিয়ে দিব খালি আমরা ডেসক্রিপশন দিয়ে দিব না say something activity কমানো হয় আর পাঁচটা অ্যাপ্লাই দাও more time engagement process. After strong vote of favor. What to do? What should be? 28. That has been not yet done because Motopani Nasulu and 26 today, so they
Fix it. Lordship, whether CD will be required. Case diary.
In fact, they are not disputed in regards to the
Only on
that
the
thing.
law.
So only on the law point mainly, basically, because merit wise, obviously there are some. But on that day, your submission was there. It was around 2,500 crores business. So
24 crore.
24 to 24,
24 crore.
24 crores, sorry. So 24 crores were there. That is the previous in various accounts those were there. So that is there. I have already noted. Apart from that, CD is a voluminous CD may not be possible also because they are not hampering on merit on the law points only. So we'll pass the order.
Item 10.
Yes.
Right, Your Lordship.
Yes.
It's an application under section 528.
Section 528
of BNSS.
Yes, yes.
Corresponding to 482 of CRPC. But this petitioner is an advocate practice for the last 24 years in Sarajevo, Lordship.
Petitioner is an advocate.
Lordship. Practicing in Sarajevo district with a good reputation, And an informant is a petitioner and the informant, Lordship, they all belong to the same greater family. They are all living in the same ancestral plot of land without any demarcations among them. And there's already a case existing between the informant and the petitioner, criminal case, someone's going on. Now, on the date, Lordship, on 30th of January 2024, petitioner engaged two laborers to repair the house of that owned by petitioner. It's a bamboo house, probably a bamboo vera, what is that twice. So it was laborers were engaged to repair the house. Then that informant lady came, informant also his cousin brother's wife, and scolded the laborers, and she had driven on the ladder, did not allow them to continue. They stopped the works. But the petitioner came to know about 1 p.m. He had gone back to the laborers and asked them to complete the work. Well, that is the house where petitioner's brother is living, Vijay. That time she created a lot of sin, Lordship, that with filthy language has scolded the petitioners. Ultimately, petitioner being an advocate, Lordship, he left the place. He came back. Thereafter, that informant had lodged an FIR, surprisingly, against the petitioner. That is in page 33. A lot of serious allegations and accept too. The English translation copy is page 33. Most humbly stated that today at about 1:30 p.m., Sri Jodhomani Das, after having unlawfully entered into my campus, created a land-related dispute, and additionally by physically assaulting me, he touched my body and torn my clothes and attempted to rape me. At that point of time, I started shouting. He fled from my campus. For information, the good sir stated that earlier also, Ajah was lodged against Jodhomani Das and his family. This is the lots of serious allegations here. In fact, nothing had happened on that day. Now, it is come to know that the informant herself went to the got her medical examination done without reference by any police. And that she said her bodily injury, but medical report, the Lordship will find it at page 52. There is no bodily injury. That itself shows that it was page 52. No external injury, Lordship. What is therefore, Lordship, that and that page 51 also.
This one, herself examined by the doctor, but the question is that subsequently was there any examination by doctor?
A record doesn't say that. She herself, the police relied on this only. Police did not refer her case.
And
Subsequently-
otherwise also the case is registered under which sections? 323 is there.
It's registered under FIR is under 447, 323, 354, 354B. But when the charge sheet was submitted by the police,
And
it was subject, the 323 was dropped by the police because there was no injury at all. And interestingly, the police did not examine those two laborers. Who created the entire scene? They were initially revoked by the petition, informant did not allow them to work. Then subsequently also, they are the people who started working, then all these things had happened. But those two laborers were not examined by the police. They did not cite their names also. They were the actual eyewitnesses.
Anyway, what is the stage of the case at present? What is the stage of the
It
case?
is fixed for evidence.
Fixed for evidence.
Lot. That Lanet court below has framed the charges under 447, 323, and 354. And that, if I may submit, Lordship, that 447 is not reflected at all because that is the common plot of land all living. The question of trespass doesn't arise. There is no land has not been.
They are from same family member or?
The same greater family. They all from the same ancestral, living in the ancestral land. Then 323, there's no bodily injury. How the landed court below has framed the charge on 323. This is something sort of cannot be accepted. And 354, Lordship. The laborers, the eyewitnesses are not examined. How the police have come to me?
Oh.
So, he is being advocate, you know.
Yes.
Call for the.
It's the search sheet case, my lord. So after filing of the search sheet, my lord, Lordship will may come to my lord page number 49, my lord. So that is the annexure 7 is the order my lord framing search, my lord.
Yes.
Last paragraph, my lord, second last paragraph. My lord, these were the section it was dropped, my lord. Accordingly, the accused person is discharged from the offence punishable under section so and so. Now, such charges under section 447, 323, 354 of the IPC of IPC frame, which are read over and explained to the accused person, which is either not guilty and claimed to be tried by. So after my lord, investigation of the case, my lord, started submitted, my lord, and my lord, Janet trial court also, my lord, found my lord, these are the materials available, my lord, in the record, my lord, that's the charges have been kept. So at this stage, my lord, notice may be issued, my lord. So the appearance of the opposite party is necessary.
I only pay at this stage notice to be issued and till returnable date, some protection will be given to him.
No protection
Yes.
required, my lord. What is the protection required, my lord?
He being
That is already said, he is on bail, my lord.
Proceedings may be suspended during this period, state, because being an advocate will be very embarrassing for him. Being an advocate practicing there for last 24 years, of course, that doesn't give him license to create all this.
That may not be a valid ground, my lord.
That's a
That cannot
different,
be
that is a practical ground, but it all appears that nothing can in fact happen because London Mason also dropped all the charges. Police also dropped 323. No injury, nothing is found. And already they had a criminal case existing between them. Therefore, civil nature case is already pending between them. Therefore, this is out of grudge or created situation that's artificially created. In any case, Lordship, kindly issue notice and call for the reports. And for the time being, Lordship, stay the proceedings. Why?
Mr. R.P. Kakoti, the senior advocate, assisted by Mr. U. Chaudhary, the counsel for the petition, and also heard Mr. Anji Borwa, the learned additional PP appearing on behalf of state respondent. Baki Hindukiva, this is an application under section so and so against the impugn order dated 26/7/2024, passed in PRC case number 54 of 2024, whereby the learned SDGM M Soradio. Sonari has pleased to frame the charge under section 447, 323, 354 IPC. Issue notice. Also call for the scan copy of the LCR. No formal notice is required to be served on respond number 1. State respond number 1, however, requisite extra copy may be served during the course of the period. Next product, Mr. Otopir, Ilwan Senior Advocate, further submitted that there was a dispute between both the petitioner and the respondent side for their ancestral land, and they belong to the greater family. Full stop. Some civil disputes are also pending in courts for some disputed land. The allegation which are brought in the FI is but only due to the dispute, but only due to the dispute between the parties, the false and concocted allegations have been brought against the present petitioner. Full stop. He further submitted that initially the case was registered under section 447, 352, 350, 323, 354, 354B, 506 IPC. However, at the time of framing charge, the learned court below had framed charge against the present petitioner under section 447, 323, 354 IPC. But there is no material to frame the charges under the said section of law, and accordingly plead that till the disposal of the present petition, let the further proceeding may be stayed accordingly. Next, considering the submission made by the learned counsel for both sides, the further proceeding in respect of the present petitioner pending before the in case number and DD so and so pending before the learned SDGM M Sonari, we state till next date of listing. List accordingly after 4 weeks.
Sleep log like.
Hearing item 27.
May I please, Lord?
Yes.
As on today, Lordship, 340 days on custody, Lordship. Case is already charged and charge also framed under section 20C and 29 of NDPS Act, Lordship.
How many days?
340 days, Lordship.
340 days.
Yes. Charge sheet already submitted. Charge also framed under section.
Is submitted. Charge under section
20C and 29 of NDPS Act. There are 18 witnesses.
20. 20.
20C and 29 of NDPS Act. And Lordship, there are 16 witnesses in this case. Already 8 witnesses already has been examined. And Lordship, may kindly for a moment, kindly see the FIR page 10. Third para, below the 8th line, Lordship. On bring interrogation and the alleged person revealed that a vehicle bearing number so and so carrying 30 packets of suspected ganja keep concealed in a private chamber of a vehicle is coming from Tripura towards Lanka and will reach in some time. The alleged person also revealed that a person namely Bhutan Ayas, address so and so, is the owner of the said suspected ganja. There are 4 accused persons was arrested in connection with this case, Lordship, along with the petitioner. This petitioner is a driver, Lordship, and contraband has been seized from the secret chamber of the Tata vehicle, Lordship. So my submission is that, Lordship, the length of detention, and this is not a conscious position from my petitioner, Lordship, and he's a permanent resident also, Lordship. There is no chance of abscondence avoid the trial. So considering the all aspect, Lordship, with any condition, I may be allowed to go on bail, because if you my custody, I have failed to defend my case, Lordship. And he's a driver, Lordship. He's only the bed earner of his family, Lordship. Because he's a permanent resident, there is no chance of absconding avoid the trial. and goods were not seized from my conscious position, Lordship. It's a secret chamber. The owner is involved, and this FIR was written by the SI. He also specifically stated that Bhutan IS is the owner of the contraband ganja, Lordship. This is my submission, Lordship. With any condition, Lordship.
Yes.
My lord, it's a commercial quantity, my lord. 65 kgs of ganja recovered, my lord, from the vehicle. And he was the driver. 38 case, my lord. Out of 16 witnesses, 8 witnesses have already been examined, my lord. And out of the 8 witnesses, my lord, PW5 and my lord, PW8, my lord. They had specifically implicated this accused person, my lord. So, my lord, regards of 37 will come, my lord. So, at this stage, my lord, I oppose, my lord. Let the some more witnesses be examined, my lord. So, there are sufficient materials, my lord.
Out of 16, already 8 already examined, Lordship. I'm not on that.
If the 8 witnesses have not implicated him, my lord, that the case would have been different, my lord. 2 witnesses have implicated him. So there are materials, my lord. Because Lordship has to draw satisfaction under section 37 of the NTPS Act.
If it is a conscious possession of the accused, then something different, Lordship, because it is seized from the secret chamber of the vehicle, and the FIR itself reveals that who is the owner of the contraband ganja, Lordship. So it is clear that case, Lordship. Some maybe police officer may be implicated in the evidence test. There is no issue, Lordship. And is a permanent resident. There is no chance of asking to avoid the trial. Already 8 examined, only left 8 witness. He's a poor driver, Lordship. He's the only breadwinner of his family, Lordship.
So your hearing is up to date, updated. This one is.
But yes, but it has come, my lord. The last witness examined was my lord PW8, my lord.
Yes, on which date it was examined?
Yet I have to go through, my lord.
Now, today is also case is fixed in Huzai, Lordship. For evidence, only 8 witnesses examined till today. I know that, Lordship.
In the month of September, my lord, PW8. September or August, PW8.
Normally, they after one month for 45 days, that has fixed for evidence. So till today, 8 witnesses examined. That is, I have full instruction, Lord. And today is also they fixed in lower court, Lordship, in Huzai for evidence.
Today, no witness was there.
Not
that report may be called for, my lord. That report may be called for today.
With any strict condition, Lordship may be considered, Lordship.
See, question is that obviously your period of detention is undoubtedly 340 days. It's
Yes.
quite a long
Long
detention.
period.
That cannot be doubted. But at the same time as the commercial quantity, that apart, it's not that the case is not proceeding. It is actually 8 witnesses have already been examined.
Yes.
So today, what is the progress, or in between, is there any progress that is not before us?
Yes, Lordship.
At best, as he pointed out, I don't know, I have not seen the CD, but he has pointed out the PW5 and PW8 and already implicated you, that though it cannot be considered as there is no implications is there, or it will not attract the 37 or rigor of 37 that are there. So let us, otherwise, today is before vacation, will it be possible? Any?
Fix a date and my lordship may call for the absolute status report. Or in the month of January, immediately after the opening.
The time he is already in custody for 340 days. That is.
Question is that, my lord, it's a commercial quantity.
I mean, obviously.
Secondly, my lord, the witnesses are implicated. Even, my lord, if the out of 8 witnesses, none has implicated him, my lord, then, my lord, he might have a case, my lord. His case, my lord, he has been implicated.
Before January, can it be any day?
For January, lordship may fix it on, my lord.
As per you, today was the date, and
Today is fixed for evidence, Lordship.
No, 18th of December, my lord. And in the meantime, my lord, lordship may call.
Because on the last day, don't fix any date because it may
last
be.
day is 20, my lord, so we are fixing on 18, my lord.
18,
Subject to
okay,
my lord.
okay. We are fixing on 18.
Hard
করে দিব আর Mr. US Borgohan and also আর Mr. Swenso updated Case, updated scan copy of the case record be called for with a report as to whether any witnesses have been examined after the
After
PW8.
26/11, madam.
After 26/11, no, after 26.
11. Today is 26/11. So today is the late fee before the trial court, madam.
No,
next
A
day.
to next
18
20
December.
year, your last PW8 was examined when?
So that is in the month of September, madam.
September. After examination of PW8, registry will do the needful. List accordingly on 18th of December.
Apply.
28.
Yes.
Today's case record and exchange of it. Court is holding in.
So we have received, I think.
Petitioner is jail in 16/11/2023 lordship, 375 days lordship.
He is in custody since 20.
16/11/2023, 375 days. 16/11/2023.
Yes. 375 days. How? It's not yet 1 year.
2023.
My lord, I have perused the,
More than 1 year, okay, and anyway.
I have perused the second copy, my lord. It is not up to date, my lord. So last month it was fixed for consideration of search, my lord. Last date was fixed on 4/7/2024 for consideration of search. After that, my lord, what is the status? It is not clear from the scanned copy of the record, my lord.
But even after lapse of 1 year, till now charge is not yet, I mean.
No,
not
search
yet
is not there, my lord. Search is submitted, my lord, on
When? CS when submitted?
is not there, my lord. Search is because it doesn't start.
You might have annexed the copy of charge sheet here?
No, they have not annexed.
You have not annexed.
But Hamu Sabizam, let the after status report maybe call for, my lord. Because search is not friend, my lord. The contraband, my lord, recovered is not a huge contraband, my lord.
Case was registered under which section? 20 or
22C, my lord.
22C?
25.
Same agonish order video updated to a scan copy along with the present status report of the case. Registry will do the needful. Same order. Yes, for when January.
Not before that.
Before that too may not be possible.
Not possible, my lord.
1 January may after which 9 January will do. 9th of January 2025.
29.
Yes.
Lordship, regular bail application, Lordship, today is 172 days, Lordship. And the offense is under 21C and 29 of the NDPS sections. Lordship, 172 days, Lordship, considering the length of detention, Lordship may consider. Otherwise, Lordship, FSL report is called for.
Was awaited, acha.
My lord, in this case, my lord, whatever, my lord, there are several, around 4 to 5 accused person, my lord, unaided in this case, my lord. And the bail application is pending before this honorable court for long, my lord. Because, my lord, one accused filed bail application after the another filed bail application. That is why, my lord, case diary could not be updated. So, my lord, let the date may be short, that may be fixed, my lord.
No, because he is under custody since 172 days.
172 days, my lord.
No FSL report is
It is pending to collect the FSL report, my lord. Otherwise, my lord, commercial quantity has been recovered from his possession, from their possession.
Undoubtedly commercial quantity, but the question is just 172 days. Hardly 7-8 days left.
That too without
If
FSL.
we.
Then
if we
FSL
cannot-
report, if not yet collected, then it is the lapse of the part of the investigation of the IO only.
That may be within 7 days, my lord. If
Yeah.
within 7 days.
Next week or
When they
whatever date আছে।
mandatory period will be over.
On 6.
6/12 will cover.
No, 6, my lord, it will cross, my lord.
6 feet will cross, 6 feet will
Cross,
cross. 3/12 হলে কেতিয়া হ'ব? আজি কিমান
That
তাৰিখ?
will fix on 3rd of December, my lord.
3rd of December.
And
We
we
fixing
stand
it
by
on-
the case diary, my lord, call for the update case diary.
Stop, to লিখো। Heard Mr. SK Sinha. Sinha, the counsel for the learned counsel for the petition, and also heard Mr. R.J. Borwa, additional PP. It is submitted by Mr. Borwa that as the case diary could not be returned, the IO is not in a position to file the updated case diary, and hence he prayed to call for the updated case diary along with the FSL report, if any, collected by the IO. And then you want to return the case diary?
Yes, my lord, we'll return the case diary and we'll call it within a short time.
Return the case diary immediately. List the matter on 3rd, 3/12.
If they, my lord, it could not produce the FSL report, my lord, then my lord, on 4th, my lord.
Obviously, and then if
They
179,
can
180
take
days.
instruction from the IO whether they have received the FSL report or not. If not,
No, my lord,
without
they will
FSL,
wait-
Lord,
they will
On
wait-
that day, if
custody.
suppose FSL report 9, we may instruct the investigating, I mean the additional PP to just collect the information whether FSL report has been submitted or is there any process of filing the CSN or we'll file it.
Okay.
30. Kindly adjourn the letter for it.
On the last occasion also, there was a prayer for adjournment.
From petitioner side.
Huh?
From petitioner side.
Or it was from your side?
Yes. We
You're
don't
appealing for
have any
NCB?
objection. Lordship,
Yes, what is something?
Lordship, we don't have any objection, but
So and so appearing on behalf of Mr. Kyle, the council, the standing council NCB. And also heard MS. No, council NCB for the respondent, and also heard MS. JS-Info, the learned counsel for the petitioner. It is submitted by MS so and so. And the request has been made by the respondent on behalf of the NCP for an adjournment. To which the petitioner side is no objection. This matter, how many weeks or how many, because the copy of the scan record is already been there, we have received. So when it can be fixed?
Any day, Lordship.
Next week, any day?
9/12.
9/12, we're fixing. Okay.
Next, Lordship. 31.
May please, your lordship.
Yes.
Lordship, offences are under 20B2C, 25 and 29 of the NDPS Act. Now, I'm in custody since 17/4/2023. That is a
17/4/2023.
That is a period of around 590 days, 1 year, 7 months, and 10 days. So, lordship, I was arrested on 17/4. Thereafter, the charge sheet was laid on 31/8/2023. And it was, the charges were framed on 15/3/2024. Thereafter, it was fixed on evidence on several occasions, but on 30/10/2024, the PW evidence was taken and he was discharged. So out of
one PW or two PW?
One PW only.
and the listed number of witnesses are 9. So after a period of 1 year, 6 months, the first witness has been examined. So there is absolutely no chance that the entire trial will be completed anytime soon. So considering the delayed period of incarceration, that will override the statutory embargo under section 37. So considering this ground, your lordship may grant me bail. And another ground is regarding the conscious possession. I was the driver of the said truck, and in my interrogational statement, I had stated that on the fateful day when I was called upon to drive the truck was already loaded up with bamboo. Thereafter, I was instructed to carry it to UP from Tripura. Then on the Naka checking, they stopped the car, and after they took out all the bamboos, they found the contraband which was concealed under the bamboos. So I had no conscious possession. So these are basically the 2 points.
This case, my lord, 1,420 kg of ganja recovered, my lord. And it was recovered from a truck, my lord, as my learned friend has already submitted, my lord. So my lord, next date is fixed on, my lord, for 2110, my lord, probably one witness is examined, my lord. But that is not in the, my lord, scan copy of the record, my lord.
Not there.
Not there, my lord. He has submitted one PW examined, my lord, but it is not in the scan copy of the record, my lord. So my lord, then the scan copy, after the scan copy, maybe call for, my lord, because what he has deposed, my lord. Because it's a commercial quantity. My
But you have received this one the prior to 110 to 2110.
My lord, it's not up here.
Do you have any other instructions there regarding during this period? Other PWs were also
No,
examined.
no, I have instruction that only one PW has been examined on 30/10/2024. So if your lordship considers only the delay point, so
By the time we just see the progress, as you have submitted, that only one, obviously maybe one, because if it is on 30/10, within 1 month, may not be also.
and the next date I have the instruction is on 21/2/2025.
21/2/2025. Yes, what to say on 21/2/25.
Prior to that, my lord, probably no witnesses will be examined, but my lord, we have to go to the statement of the one witness, my lord, PW1, what is the cause. And secondly, my lord, there are materials because that is a search has been submitted, my lord. This is implicated, it was recovered from his conscious possession, my lord. It was his knowledge, my lord, that my lord, that ganja was in the vehicle. He should have refused it, my lord, when he was asked to drive the vehicle from Tripura to my lord, with UP, my lord. But he has not denied, my lord. So it was his knowledge that the ganja was hidden in the secret chamber.
Your lordship, I have the interrogational statement. I may be allowed to read that. 4 or 5 days ago, an unknown person called me over telephone by an unknown number and asked me to drive a truck from Khajur Bagan. And the person told me that he got my number from the transport agency. As the person called me on 15/4/2023 in the morning, I reached at Agartala railway station, and one person came to pick me up by a white colored Tata DI vehicle, but I did not notice the number. Person had picked me up from the railway station. It's about a 40 to 45 years old tall man. The unknown person brought me to an unknown place, which is about 15 kilometers away from Khajur Bagan, Agartala, and the place was surrounded by bamboo plant. At that time, the truck was fully loaded with bamboo, and I had no idea that there was any illegal item concealed under the bamboo bundle. So this is the interrogational statement of the petitioner.
This is the statement of the accused person.
Yeah, obviously, but he is saying that he was not aware of what is the about the loading of the any contraband over there. Anyway, okay, we call for the same order for you. নামকেইটা লিখিব it is submitted by Mr. Borwa, the learned additional pupil, that though it is submitted by the learned counsel for the petitioner that one PW has already been examined on 30/10/2024, but scan copy has no but the evidence of PW1 is not available in this scan copy. which has been received, and accordingly he prayed to call for the updated case diary along with the evidence of PWs, if any, if PWs recorded, if any. So he's, as per his submission, the next date is fixed on 21/2/25. So it can be either prior vacation or after vacation, as you have seen.
After vacation only, my
Lordship, prior vacation, if it comes down.
How
to
many
better.
matters will be disposed of on prior vacation? It are Dilwami or finding. We are trying, but don't make any keep any cases on 2021 of Narakigo, 1920, 19 and 20 Narakigo.
Well,
We're trying
Okay.
to list it on 12 years.
32.
Yes.
Yes.
What the certificate is earlier, records were called from lawsuit. Lawsuit.
Pardon? Record was called for.
Lawsuit.
32 record is already received, I think.
yes, madam. Scan
Yes.
copy record. Scan copy received, my lord. In this case, my lord, one PW's examined, my lord. There is a case of my lord 379 and 22C of the my lord NDPS Act, my lord.
379 also.
379, my lord. There is an allegation that my lord he has stolen one my lord ATM card of a person, my lord, informant, and he has withdrawn my lord fraudulently 35,000, my lord. And thereafter, my lord, this contraband was recovered from his possession, my lord.
Not from his possession.
Earlier, the case was registered under the IPC section.
Lordship.
Thereafter, only while at the time of investigation,
My lord.
it was founded. He also did
So, my lord, that is the-
Lordship, kindly come to Annexure 2 of my bail petition. It was recovered from one Moinuddin,
recovered from
a house of one Moinuddin, Lordship. Page 14, Annexure 2, Lordship. Initially, case was registered under 379. Subsequently, this section was added. Page 14, Annexure 2, Lordship. It was recovered from place of search seizure, house of Moinuddin, village Nandanban, Lordship. And it is from the house of the Moinuddin, Lordship. According to the prosecution, accused person was there. And the Lordship, he was arrested on 17/1/2023.
Moinuddin is also one of the co-accused.
Lordship,
No, my lord, he is not the co-accused.
he's not.
It is in the house, but he was in the house, my lord.
Oh,
The accused person was in the house. The house belongs to Moinuddin, my lord.
Moinuddin.
The house only belonged to Moinuddin.
Moinuddin.
By recovery was from him only.
The recovery is from him. And my lord, on 7/8/2004, my 2024, one PW examined, my lord, and he turned hostile, my lord.
That is Lordship at page 47 Annexure 8. And he is one of the seizure witness. Page 47 Annexure 8.
He was a seizure witness.
Lordship.
He turned hostile.
Lordship. I have seen police bringing one person to our village. The person is not present in the court today. Accused is not the said person, so he denied that. And my lord, I'm not on merit already 1 year, 10 months.
1 year,
10 months.
10 months.
No.
How many witnesses examined till now?
Only one.
Out of the 13 witnesses.
Out of 13.
Out of 13. The last next date was fixed on my lord as per the status report, 16/11, my lord.
There may not be any such progress. Okay, we'll see to it. Is there any? Yes, you want to submit anything? Release.
Hardship in this case, Honorable Apex Court granted bail.
Considering period of
Period of-
incarceration.
And our High Court, there are two judgments, your lordship, one such as your lordship. I believe.
Okay, we'll pass your order.
All right.
My lord, place one decision, my lord. 1999, 9 HCC 429.
Just a second, 19.
1999, 9 SCC,
9 SCC.
page number 429. Paragraph number, my lord. 4, 6, 7, and 8, my lord.
Parties are?
Parties are, my lord. Union of India versus Ram Somos and another, my lord. So in this case, my lord, in the absence of satisfaction of the conditions under section 37(1)(b), the High Court's order granting bail to an accused is bail. So satisfaction has to be done, my lord. Because it's a commercial quantity.
All right.
It will file will anybody use. 1999.
Yes.
9 SCC.
Yeah, please, your lordship. Keldari was,
34 Keldari, no.
my lord, can it be on Friday, my lord? From Teshpur, my lord. Two occasions, Keldari has not been received, my lord. Can it be on Friday, 29th, my lord?
Friday, I don't know. Friday, can it be possible? I mean, don't take it Friday. Because again, same.
No, it
same thing
will
may
come, my
happen.
lord. On two occasions, it has not come, my
No,
lord.
whatever. I'm saying for you only.
My lord.
Because may not reach.
My lord.
Because today, if it is CD is returned also, possibility is less. That's why I'm saying. Otherwise, it's okay. What is the nature of case? This one?
21C, commercial quantity only, my lord. But
He was
nothing has-
arrested on 9/8.
9/8, my lord, that's why, my lord. But nothing has been seized from me, my lord, that's why. If possible, my lord, can be on 29th. We'll try.
Friday, I don't think Friday will reach. Yes, Burwa? Can it be reached on Friday? Friday may not be possible. I think.
We have not received the case diary, my lord. She may
That's
fix
right.
it, but question is that if case diary does not come, my lord.
Yes, that's what I'm saying. Friday, if you may,
We
you
have-
may issue reminder also.
Yeah, we have issued reminder, my lord.
That's why, my lord.
1411 also.
Otherwise, my lord, on Monday, my lord. Second, May,
I think better to take on Monday only.
my lord.
Because Friday may not reach.
My lord.
Ako reminder issue করে দিব, may not reach. Friday, Monday is second.
Second, my lord. 2nd of December. Keep your best.
35.
May I please, your lordship?
এটা কোনটো আছে? এটা আগতে হৈ গৈছে ন? Yes.
My lord. Lord, the offense is under 22C. It's an anticipatory bail application, my lord. The FIR is at page 9. Basically, the allegation against the petitioner is that two persons has been apprehended by the police, and during investigation, they have confessed that whole Sempex plus capsule has been it is confessed that whole narcotic drugs were provided to them by one Muktaz Ali. This is the petitioner here. So basically, on the mere confession, this petitioner has been named in the FIR. My lord, no way connected with the accused person, other accused person, number one. Number two, no incriminating material has been seized from the petitioner. And on a confession, my lord, it's no evidence.
If your lordship have a look at the FIR, my lord, at page 9.
Yes.
With reference to the subject cited above, this is to inform you that reliable information was received from so and so. I will not bother your lordship by reading all this. I'm reading from the last 4 lines, my lord. At Sorokothar Sonari Basti, we intercepted 2 persons, namely Saddam Hussein, so and so, and Abdul Qadir, both resident of Sorokothar Sonari Basti, with a motorcycle bearing number so and so, so and so. 11520 numbers of Sampex plus capsules were recovered and seized from 2 bags kept in the motorcycle as per seizure list in the presence of witnesses. The witnesses were examined at the place of occurrence and recorded their statements under Section 180 of BNS Act. The apprehended persons were also interrogated at the place of occurrence and recorded their statements. In their statements, they confessed that the whole narcotic drugs were provided to them by one Muqtazal Ali, son of so and so, for transporting to Haurakad. The seized articles were sealed as per procedure at the place of occurrence in presence of independent witnesses. After completion of all formalities, I along with staff so and so with apprehended the accused persons. That 2 accused persons were apprehended. The petitioner is no way connected with that offense. Number 1. Already I have submitted before the lordship. No incriminating materials has been seized from the petitioner. No Sampex capsule, no drugs has been seized. Therefore, considering all this aspect, my lord, and under Section 25 of Evidence Act, it's no evidence confession, my lord. Lordship is aware of that. So, considering all these aspects, this bail application may be allowed, my lord.
Hello, in this case, we received the case diary, my lord. My lord, 11,520 numbers of capsules were recovered, my lord, from these accused persons, my lord. 2 accused persons. Their name is, my lord, Saddam Hussein and Zakir Hussain, my lord. Now, my lord, they were interrogated, my lord. And when they were interrogated, my lord, because they were interrogated regarding to know about the source of, my lord, from the where they have received the, my lord, contraband. Then they have implicated this person, my lord. He has, my lord, earlier also he used to, my lord, supply the contraband, my lord, and they sell in the open market. And this time also, my lord, this person has supplied the, my lord, contraband, my lord. Now the case is pending for FSR bill, my lord, FSR report, my lord. So this is anticipatory bail, my lord, so I oppose, my lord. It's a commercial quantity. And regarding, my lord, grant of anticipatory bail, my lord, I only place one decision, my lord. 2022 live law, my lord. live law, Supreme Court 22, my lord, page number 22. State of Haryana versus Somot Kumar. In this case, my lord, the Tufan Singh was discussed, my lord. So what is the, it was, my lord, hold that, my lord, although Tufan Singh ratio is, my lord, correct, because, my lord, on the basis of co-equal statement, my lord, a partial cannot.
But while
be taken,
granting
my lord.
anticipatory,
But
cannot.
regarding, my lord, granting anticipatory bail, my lord, that has to be looked into, my lord. Because these are all organized crime, my lord. Because the person whom possession it was seized, my lord, he must have to receive from somebody else, my lord. So that is why, my lord, it's a case of conspiracy and it's an organized crime, my lord. That is why, my lord, this person's interrogation is very much necessary, my lord. So at this stage, my lord, I oppose, my lord. So it's a, my lord, full party application, my lord, and FSL report is yet to have received.
Heard Mr. PM Deka, the council on council for the petitions. And also heard Mr. R.J. Burwell, the Daniel additional PP appearing on behalf of state respondent. This is an application under section 482 BNSS, paying for granting anticipatory bail to the present accused person. For the present petitioner. It is submitted by Mr. Deka that the one case has been registered by Jogonamo Police, Jogonamo Police Station, wherein 2 co-accused persons were intercepted by police, wherefrom a huge quantity of and where from 11,520 numbers of Samplex capsules recovered, which were kept in 2 bags in the motorcycle. On interrogation only, the statement was made by the apprehended persons that the present petitioner is involved in the alleged offence. However, nothing has been recovered from the possession of the accused, neither any incriminating materials nor any contraband from the present accused petitioner. He is no way connected in the alleged offence, and more so the confession made by the co-accused before police cannot be taken into consideration, and accordingly he submitted that this is a fit case wherein the privilege of pre-arrest bail can be granted to the present accused petitioner. However, he will appear before the for the investigating officer as and when his presence is required. Next para, Mr. R.J. Purva, the learned additional PP submitted in this regard. CD receipt Purva. CD receipt. Submitted that from the materials available in the case diary, it is seen that the present accused petitioner is the kingpin of the case, who used to supply the drugs, who used to supply the contraband to the persons to sell in the open market. So sell in the market, but and in this case also the recovery was 11,520 numbers of capsules, which is a commercial in nature, and accordingly the case has been registered under section 22C/29 of NDPS Act. He further relied on a decision of Samad Kumar, which was reported in 2022, Live Law, Supreme Court 22. Wherein also it has been expressed by the apex court that the ratio of Tupansing may be applicable in case of regular bail, but that cannot be considered at the time of the granting the anticipatory bail. Next para, considering the entire submission made by the learned counsel for both sides, nature of allegation, vis-a-vis the materials so far collected by the IO, I do not find it a fit case to extend the privilege of pre-arrest bail to the present accused petitioner. So, and accordingly, same stands dismissed. Your petition stands dismissed.
My lord, much obliged.
54 of the supplementary list.
50.
May please, Lord. A suspected case, madam. Petitioner is in jail, madam, for 190 days till date, madam. The FIR, madam, against which, madam, we have to see this. Case 13 is the
190 days, CS is submitted.
CS submitted, my lord. Evidence also, my lord, started, my lord. Already the informant has been examined, my lord, also cross-examined. But he does not implicate the petitioner. Page 13 is the FIR, my lord. Page 13. With due respect, it is to inform that about 3 months ago, from today, the opposite party eloped the daughter of the applicant, Srimati so and observed marriage. Immediately thereafter, the opposite party has been started to harass the daughter of the applicant, both mentally and physically, in demand of crowd. In this respect, Devolina has informed the applicant few days back. Today, about 2 p.m. of the day, opposite party informed the applicant about whom that his daughter got expired. Having found no clue, the applicant immediately rushed to the house of the accused and found that that daughter of the informant lying dead in her bedroom. Injuries were found all over the body.
and the opposite party fled away from the house after killing the daughter of the applicant in a planned manner. The other family members of the opposite party also have their assistance in commission of the offense, my lord. This is the FIR against me, my lord. Now, your lordship, kindly consider, my lord, page 28, my lord. Another FIR, my lord.
And the FIR is lost by whom?
The same informant father, my lord.
Achha.
What happened? The earlier daughter of the informant, my lord, went with one Akbar Ali, my lord. On 14/2/2024. On that day, the informant has lost an FIR, page 28. Kindly pay it. Page 28.
Where it is written that she went with one Ali Akbar?
My lord, the page 29, my lord, the IO after inquiry, my lord, he submitted a report, my lord. Page 29. I have inquired the matter by so and so. Is found there is a elopement case. Therefore, I request to kindly register a case with proper section of law. When the boy was arrested, the boy who loved the daughter of the informant, Akbar Ali, the informant, he was arrested. The daughter of the informant again eloped with me, my lord, the petitioner. Immediately thereafter, my lord, she eloped with the petitioner, my lord. And after my lord, 3 months, my lord, she committed suicide. Since my lord, she has love affair with the earlier lover, my lord. I have annexed the my lord, WhatsApp SMS, my lord. The lordship will kindly pay it. With the earlier person, my lord, with whom she has my love affair. Page 53 and 54, my lord. These are the extracts of the my lord WhatsApp SMSs taken from the bail application filed by the Akbar Ali. And I have also annexed the bail petition, my lord. Bail petition started from page 37. And the most important part of the bail application, my lordship, kindly peruse page 40, paragraph 4 of the bail application. Of the Akbar Ali, my lord, with whom, my lord, the daughter of the informant earlier eloped. Page 4 of paragraph 4, page 40. As a lordship got, my lord.
Is whose application this one?
My lord?
Whose petition this one? Earlier.
Akbar Ali, the earlier person, my lord, with whom the daughter of the informant eloped, my lord. Page 40.
See, how can assassinate the character of a girl? I don't know. She may have adopted the boy, but the question is that she died now.
She committed suicide, my lord.
And the case is accordingly registered 304B.
My lord. There are two cases, my lord, registered against one Akbar Ali and against the petitioner, my lord. In both cases, my lord, the informant has examined as PW1 and he has been cross-examined also, my lord. I have the copy, my lord. So kindly pay with my lord. They will let you.
Case is also registered under POXO.
She is just 2 months, my lord, below than the 18 years, my lord. There are two cases, my lord. One is 66, my lord, and another is 34 of 2024, my lord. 34 is against the my lord Akbar Ali and 66 against the petitioner, my lord. The lordship will kindly peruse the cross-examination of the informant father, my lord, of in connection with case 66 of 2024, my lord. Kindly peruse para 6 of the my lord cross part, my lord. 6, 7. And my lord, most importantly, paragraph 4, my lord. I am sorry, my page 14, my lord.
Para?
Cross of 14, my lord, para 14.
Hmm. It is?
Paragraph 14, my lord.
Ah.
It is a fact that the accused Pawan Bora used to love my daughter, my lord.
Oh,
There was
yes,
no-
that's why today she loved with it. It is admitted. There was love affairs.
My lord, there is
Obviously,
no
love affairs.
implication against the petitioner in the cross or in the.
Yeah, Baba, obviously love affairs was there. That's why she eloped with that girl.
My lord.
I don't know. She prior to that, she may be with eloped with one Akbar Ali and all that. I don't know. But the question is that she definitely went with the present accused petitioner because she had love affairs.
And now lordship kindly peruse, my lord, the evidence part of case 34 of 24, my lord.
Forget about 34 to
Since it is a connected case, my lord.
Is it a connected? How can it be connected case?
My lord, the informant is same, my lord. Facts are also almost same, my lord.
Anyway, cannot be connected. Yes.
My lord, the victim is the my lord, wife of the my lord, this present accused petitioner, my lord. And there are my lord 164 statement of the two witnesses, my lord. My lord, from their statement, my lord, it is clear, my lord, that she was mentally and physically tortured, my lord, before her death, my lord. And in the my lord, inquest report also, my lord, several other injuries were also found, my lord. Although my lord, she has committed suicide, my lord. Now, question is that, my lord, as per the scan copy of the record, my lord, only PW1 informant has been examined, my lord, and his cross-examination was reserved, my lord. But my learned friend has stated that, my lord, cross-examination is complete, my lord. So let the up-to-date status report.
Cross-examination is still reserved.
My lord, as per the status report, my lord, scan copy of the record, cross-examination is pending, my lord.
It is because, my lord, since both the cases are, my lord, before the same court, my lord. If the learned court below takes evidence in one case, my lord, in another case, it was, my lord, postponed.
But in your case, the cross is already there.
Cross is reserved, my lord. In other case, my lord, the
Reserved.
SIF and the cross is completed, so far informant is concerned.
No. In your case, 66 cross is already over.
No, my lord, only examination is SIF. I'm sorry, my lord, cross is also over.
Out of 9 witnesses, my lord, only one PW examined, my lord. At this stage, my lord, if he is released on bail, my lord, he may hamper the trial, my lord. This is my happy.
But I am 190.
Those two 164 were 41. One is the victim informant. Or
One is informant, other witness yet to be examined, my lord. So some other injuries were also found, my lord, in the
I have annexed, my lord, the PM report, my lord.
It is, my lord, clear from the PM report as well as, my lord, the inquest report also.
Kindly peruse
yes,
the-
you are 40.
Informant.
Ah.
So, your lordship, first my submission would be that first of all, that the previous elopement, which my learned senior is speaking of, that has no bearing on the present case. Because the present petitioner before your lordship is not the person who she may have eloped with earlier in time. Secondly, your lordship will consider that this girl was found dead in the bedroom of the petitioner under the care of the petitioner while she was still under the care of the petitioner. So even if my learned senior says that this is a pure and simple case of suicide, but the fact is that a young girl has lost her life and there are circumstances which has led to that suicide. So those are matters of trial. So at this juncture, since the PWs have not been examined, so your lordship may not grant bail because it may totally hamper the trial. So your lordship, this is my submission in short.
My lord, page 23, well, there are only 9 witnesses. And out of them, only 4 are the vital witnesses.
And those also haven't been examined.
Already one has been examined and cross-examined, and he has not implicated me, my lord. Therefore, my lord, considering the length of detention, my lord, 192 days in custody, my lord.
54, na? You are Mr. Saikian.
Yes.
Heard Mr. PG Saikian, counsel for the petitioner. And also heard Mr. R.J. Burwa, the learned additional PP for the state response number 1. And MS MK Brown, the amicus curiae for the respondent number, the informant respondent number 2. Stop. This application under section. You are filing this application when?
My lord, it was filed on 5th of August, my lord.
5th of August. By your filing under 439 only.
My lord,
What?
my lord. 439, my lord.
439 is not the section now.
Well, recently, my lord, our High Court has held that, my lord.
What held?
In regard to, my lord, so far which section will apply, my lord?
Then what it
Is
held?
it, my lord, under the BNSS or, my lord, CRPC?
Oh.
Recently, my lord, held that it should be, my lord, BNSS.
That's what I'm saying. It should be BNSS. You are filing under CRPC.
My lord. When this bail application was, my lord, filed, that was not, my lord, decided which provision.
No, it was already decided. After July to it has already been implemented. By insisting the all to file under BNSS. Anyway, we are not ahead. Will take time then again. So again, you are filing on 439 only. Yes, Borwa, is there any what to do? Can it be disposed of?
Dispose of by rejecting, my lord.
Or 439,
The material witnesses
430.
are yet to be examined, my lord. If the material witnesses is examined, my lord, then, my lord, his bail application may be considered. If your lordship are not inclined to grant bail, my lord, then give some time, my lord, so that other witnesses may be examined and, my lord. That can be done, my lord, by humble submission.
No, why
Since,
will
my lord,
pending this one?
it
Anyway,
will
we are
once it-
disposing it.
it-
So and so. Paying bill under Topohana, so and so video. CD received, there is the same hard both side. It is submitted by Mr. Paisoikia, the counsel for the land counsel for the petitioner. The present accused petitioner is innocent. However, it is a fact that he got married with the petitioner
Victim.
married the victim after she had been eloped with him, having love affairs with him. Having love, no, after she eloped with the present accused petitioner. But prior to this also, the present victim, the victim earlier eloped with another person, namely one Akbar Ali, and on the basis of which another affair was lost by the father of the victim, and the case is still pending for disposal. Further, he submitted that as the victim had the love affairs with one Akbar Ali, she was having conversation. She used to have conversation with the said Akbar Ali, and subsequently she committed suicide. But there is but the present accused petitioner is innocent and he is no way involved in the alleged offense. Post of more so, one PW has already been examined who did not implicate the present accused petitioner in the present case. Mr. Sakia further submitted that he will appear each and every date of the hearing if the accused petitioner is allowed to go on bail. Next para, Mr. Borwa, the learned additional PP submitted in this regard that from the statement made by the witnesses under section 164 CRPC, it is seen that she was subjected to mental torture for her death, mental and physical torture before her death, and the PM report also speaks about some injuries over her body at the time of death. He further submitted that till the examination of the material witnesses, the petitioner may not be enlarged on bail. So as there is every probability of hampering or tempering the witnesses full stop. Next para. MS Brown, the learned amicus curiae, also submitted in this regard that the victim was found dead in the room of the petitioner in a suspicious condition, and the PM report and the other circumstances also reveals that she was subjected to physical torture before her death. There are some material witnesses yet to be examined by the court, and till the examination of those material witnesses, the petitioner may not be enlarged on bail, as there is every probability of hampering or tempering the witnesses of the other material witnesses. Accordingly, both the learned additional PP and the learned amicus curiae also raise objection in granting bail to the present accused petitioner. Expert, considering the entire submission made by the learned counsel for both sides, materials available in the case diary, and also considering the statement made by the witnesses under section 164 CRPC, I find that till the examination of the other material witnesses, will not be proper to enlarge the accused on bail at this stage. Accordingly, the bail petition so and so stands rejected. Your petition stands rejected.
Dowlai.
55 to 57. He was regular. Ekatagis. 55, 56, 57. These are all connected.
Connected matters, my lord, arising out of the same affair. I am appearing in items number 56 and 57, my lord. My learned
56 and 57, and
my
you are
learned friend is appearing for 55, my lord.
55.
Lordship, may kindly take up 56, my lord. So before coming to the documents, my lord, I'll just give a brief narration of what had happened, my lord. So there was an eviction drive which was carried out in Sonapur, starting from the 9th of September, my lord. The administration had said that there were encroachers, my lord, who were encroaching upon government land. Entire villages had been set up in government land. So the government carried out an eviction exercise, my lord. It started from 9th. On 12th, my lord, what happened? An altercation took place between the people who were residing there, who the government claims to be encroachers, who we are saying that they were bona fide residents, my lord. So there, an altercation took place between these villagers and the police personnel, as well as the administrative people who came for carrying out the eviction drive. But in the course of this altercation, as per the prosecution's case, my lord, these people, they had attacked the people who were carrying out the exercise. However, my lord, on that very day, my lord, there was also retaliation from the side of the police. When the police had resorted to gunfire, 2 persons died on the spot. Several other persons were, my lord, they were injured, including children, my lord. So these people were eventually transferred to the hospital. Now, 2 children who had sustained bullet injuries in their stomach, my lord, they were picked up from the hospital, and as CCL, they were produced before the JJP, my lord. JJP, seeing their condition, my lord, released them on bail on the very first day, because they were in such a condition, they were even unable to climb up the stairs to the first floor, my lord. Now, regarding the adults, my lord, these persons were again picked up from the hospital. They were arrested, taken to custody. Now, in 56, what happened? Because these people had not even properly recovered, petitioner number 9, he dies in jail. Because he also sustains a bullet injury, not properly recovered. He was arrested and remanded. Petitioner number 9 dies, and subsequently, your lordship, his name was struck off. Now, these other petitioners, they also sustained injuries. Likewise, my lord, in petition number, item number 57, that is one lady, Aisha Khatun, she had also sustained a bullet injury in her stomach. And again, after 7 days of being in the hospital, she was picked up from the hospital and arrested and now remanded. So these people, my lord, in item number 56, 9 is struck off, 1 to 8 has been in jail for 74 days, 10 and 11 for 69 days. And in item number 57, my lord, this lady, she has been in jail for last 55 days.
10 and 11 for how many days?
10 and 11, my lord, for 69 days. Now, my lord, in this case, the fact that an altercation took place is not in dispute, we are not denying. The government has a right. We will also not disputing the fact that the government does not have a right to carry out eviction. Obviously, if there are people who are encroaching, they have a right. Now, in this case, my lord, there was, even if we go by the prosecution story, there was use of force from both sides. Now, your lordship will examine which was whether the force which was used by them is commensurate, proportionate or not, because these people, according to them, attack them with lathi and sticks. They resorted to gunfire. Two persons died on the spot, one died in custody. Others have sustained injury. Now, after 74 days or 69 days, my lord, whether there's any requirement for keeping these people under custody, my lord. That is my first line of submission, my lord. And secondly, my lord, the offences which they have, my lord, invoked in this case, my lord, your lordship will examine 191 subsection 2, my lord. Now, 191 subsection 2, this is rioting, my lord. The equivalent was 147. 191(3) is rioting with dangerous weapon, my lord. 148. Now, the other section, the most important, the serious, most heinous section which they have invoked is 149. Waging war against the government, my lord. And this is the section which extends the period of detention to 90 days, my lord. Now, my lord, if persons are otherwise illegally occupying a land, are squatters, my lord, and they carry out eviction, some retaliation happens, my lord. Whether that tantamounts to, my lord, waging war against the government, my lord, that is perhaps stretching things way too far, my lord. They have had the opportunity of arresting us. People have died. Children have been shot at, my lord. Now, whether they want to keep us in custody further, my lord. What remains in this case, my lord? Whatever has happened, my lord, the trial this will come out in trial. Every possibility, half of this section will not even survive in the charge sheet, my lord. Now, we have been in jail for 74 and 69 days, my lord. So, considering this all aspects, my lord, we are humbly submitting that your lordship will balance our rights along with the rights of the state, my lord. State has had every opportunity. We are the individuals, they are the mighty state, my lord. We are against the mighty state. They have done what they have to do. They have evicted us. We are homeless. They shot us. They kept us in jail. Whether they need anything more from us, my lord. That is my humble submission.
Yes, 55. You are appearing on 55?
55 is appearing.
Achha. Yes.
Lordship, today is the 74 days in behind the bar.
How many are you representing? Only one?
Two, Lordship.
Two petitioners.
Right, isn't it?
55.
They are behind the bar since last?
74 days.
Rest of the submission you only please. Yes, you want to submit. And
Lordship, item number 59, my lord, out of same affair, Abu Hussain, my lord. 59, my lord.
59. Achha, here out of same affair.
And out of same affair, my lord.
Achha.
May I submit, my lord? May I submit?
Yes.
My lord, here in this case, I was arrested, my lord, after the alleged incident, 2 months after the alleged incident. I was arrested on 12/11/2024. I am nowhere involved with such kind of incident. I am not homeless, my lord. And I am resident of that locality, my lord. I am nowhere, never implicated, never involved with this incident, my lord. Only for allegation of criminal conspiracy, my lord. I have been arrested on 12/11/2024. That too after, my lord, 2 months of the real incident, actual incident, my lord. Now, my lord, my humble submission is that after 2 months of incident, all incident, ended up.
You are arrested
now,
on 12/11.
12/11, my
This
lord.
month only.
This month, my lord. This month. So, my lord, my custodial detention may not be required, my lord. All incident are ended up. There is no problem. All illegal persons are evicted therefrom. There is no hue and cry in this place right now, my lord. And after 2 months of incident, my lord, my humble submission is that my custodial detention may not be required. And more specifically, my lord, I am no way, my lord, involved with such kind of incident. I am a businessman, my lord, regarding land, my lord, and only for that purpose, my lord, reason, my lord, I was arrested, my lord. So that is my humble submission, my lord. I may be allowed to go on bail, my lord.
Firstly, my lord, my learned friend has given a very sympathetic submission, my lord. That's my lord. We are the mighty state, my lord. And
They are the mighty state,
my lord. We are the mighty state, my lord. but at times, my lord, they grow mightier in our state, my lord. In this case, my lord. So whether they are, my lord, my lord, eligible for sympathy or not, my lord, my humble submission is absolutely not, my lord. Because, my lord, whatever, my lord, the charges are such that, my lord, they have been, my lord, first they said that they were given the notice that eviction drive will be, my lord, conducted. Thereafter, my lord, some people from the outside, that is I'm also pointing towards the petitioner number, my lord, item 59, who was one of the petitioner, my lord. His role came into, my lord, light after the investigation, my lord. And with the people from that locality, my lord, they, my lord, assemble in the, my lord, previous day, my lord. They have resolved that when the state comes to resolve, my lord, evict them, my lord, they will fight it out, whatever may be the consequences, my lord. Even the point of, my lord, destroying the properties or killing someone, my lord. This is how they have, my lord, gathered, my lord. That is why, my lord, on that day, there are, my lord, personnel from the police and also, my lord, administration, my lord. The situation is such, my lord, created, my lord, that, my lord, it turned up, my lord, that my lord, even the police persons and other persons, they had to, my lord, go and, my lord, hide to a separate place and take the help of other locals, my lord, for saving their life, my lord. The assault is such that, my lord, they were driven back towards the, my lord, the railway line, my lord. From there, my lord, they were one part of the railway line, they were there, and they were driven back from the railway, across the railway line, and up when reaching the railway line, my lord, they again started to, my lord, picking stones, my lord, pelting stones on the, my lord, the election party, my lord. And in their drive, my lord, what happened, my lord, they all people gathered with, my lord, sharp weapons, lathi, stick, and your lordship will be surprised to know, my lord. Even one of the police person, he is also, my lord, injured with firearm, my lord. That has come out one of the medical report I have seen, my lord. My lord, firing from their side also, my lord. Your lordship will imagine, my lord, how they gathered themselves, my lord, for attack, my lord. That I am sitting from the, my lord, one of the injury report I have found, my lord. It's very clear one. So, my lord, in item 59, my lord, it is very much clear he is one of the conspirators who is instigating those locals, my lord. So I have very much objections against this person, my lord. His role has now come out, my lord. So, my lord, custody is required because, my lord, how this happened, my lord. How this conspiracy, how it is happened, my lord, and how it is created to such an extent, my lord. That has to be, my lord, unearthed, my lord. So the custody is required, my lord. And your lordship will see, my lord, rioting and something, my lord, my lord, can say, my lord. They are also, my lord, charged with, my lord, criminal conspiracy. Now, my lord, criminal conspiracy in BNSS, it carries the punishment for life, my lord. So it is a 90 days offense, my lord. And, my lord, and regarding other things, war against block, my lord, because lordship seals, section 149. If you assemble with arms against the administration, what else is required? What else is required? What is it not a war, my lord? You are protecting your land. As it, my lord, it is their land, demarcated, it is their own state, my lord. They are fighting it out. The situation is like that, my lord. And the investigation is also there, my lord. And 149 war against, again, my lord, 61 is criminal conspiracy. These are the sections attributed, that is why, my lord. And now your lordship will find the injury reports, my lord. In all the injury reports, my lord, find, my lord, they are laceration, sharp injury, though simple, my lord, but they are penetrative injury.
The police personnel sustained.
Yes, injury sustained by the, my lord. Yeah, these are all cut injuries, my lord. And all one of the injury, my lord, it is, my lord, one of the person, he has received injury from firearm, my lord. It's specifically given, my lord. And we have to undergo surgery. My lord. So it is not a simple case that they are just behind a bar, there a simple driving going on, my lord, just a simple scuffle. It is not that, my lord. It's a clear case, my lord. Clear case that they have, my lord, assembled and, my lord, attacked the persons on duty, my lord. So at this stage, and also the conspiracy side, my lord, there has to be some investigation because, my lord, otherwise, my lord, they could not have, my lord, rose to such an extent. There also these aspects has to be, my lord, inquired, my lord. So at this stage, even though one is 50 days, another is more than 70 days, my lord. At this stage, my lord, I have clear objections at this bail applications, my lord. Because 90 days should be there for at least for some days, my lord.
But yes, your submission is good, but question is that the person who are behind the bus is last 74 or 59 days.
Yes, madam.
You want to
Yes,
say that
madam,
further
because,
custody will
yes,
be.
yes, because for bail, my lord, the lordship has to see the other parameters also. The offense part they have, my lord,
Yes,
committed,
obviously,
my lord.
obviously.
It is not that they are only protecting themselves with lathis and all, my lord. They are, my lord, attempting a life upon that person's, my lord, who had come, my lord. It's very clear, my lord. And the eyewitnesses, my lord, even the eyewitnesses have stated all these things, my lord. They, the grievousness of the offenses has to be seen, man, before releasing them on bail, my lord. Because 90 days is the, my lord, they are not statutorily, my lord, they are not illegally detained, my lord. Because there are some judgments also to that effect, my lord, while considering the bail application, my lord, whether the witnesses will be hampered, whether their, my lord, the gravity of the offense, everything has to be seen, my lord. And that is why, my lord, seeing the gravity of the offense, my lord, I am objecting to this all bail applications, my lord, at this stage, my lord, even though it is more than 70 days, my lord. And one is only 14 days in custody, that is item number 59, and another is 55 days in item 57, my lord. And if your lordship wants to peruse the, my lord, CD, my lord, I can hand over it, my lord.
57 is
57 is, my lord, 55 days,
55 days.
and 56 is 74 days and 69 days.
74 days, and 59, 14 days.
I'll just respond to what my learned friend is
And your
submitting.
lordship, if your lordship desires to see the case diary, my lord, I can hand over it, my lord.
You can.
Lordship.
Small rebuttal, my lord. First of all, my criminal conspiracy, nowhere I have seen criminal conspiracy, nowhere carries back imprisonment. Perhaps my learned friend has read it wrong. Whoever 61, life, that is punishable.
Whoever is a party to a criminal conspiracy,
who committed
an
offense
offense punishable with death, imprisonment for life, or rigorous you have attempted for the life.
So where I am submitting this section
Because
140
there is conspiracy.
Yes,
Whether death is
let me submit.
or not. my
So
lord.
my lord, whether if 149 is attracted, they don't need the support of 61 to make it a 90-day offense. What I am submitting is that 149 is not attracted. If 149 is not attracted, then they cannot hang on to section 61 to claim it is a 90-day offense. Then my lord, we are not seeking default bail. We are not before this honorable court seeking default bail that we have to wait till 90 days. We are seeking bail on merit. Your lordship will consider, your lordship will either reject or allow. We are not seeking default bail. So this cannot be a submission that we have to wait till 90 days. By that, if that, because that is the analogy, then these 481, 483, all of this becomes of use, my lord. And secondly, my lord, when they have said that these people have sustained injuries, police officers have sustained, nobody is disputing that. But if it is to be properly balanced, nobody has died on their end. Here people have died, my lord. One person has died while they have, without his proper recovery, my lord, they have taken him out from the jail or from the hospital. He dies in hospital. They cannot return that life. 2 persons, my lord, I have already annexed it. My lord will find it at page 27.
For their own fault, my lord. If you are taking.
No, you did not. Let me submit. Let me
returning,
submit. You have already submitted. I did not interfere. The government does not have the right to take my life. The government does not have that right. So when they say it is my fault, they, as I'm saying, my lord, they have the entire forces with them. So there is no need to kill me, my lord. They shot in the stomach 2 children, my lord. So I have seen your lordship's empathy towards children while dealing with POCSO matters. The state does not have any empathy when they shoot children, my lord. This there in the case that it will come up whether they shot children or not. When they are defending their actions, they are saying that we are squatters, we are saying that there is due process.
You have evicted us. We are not challenging those actions in court. You have evicted us, but does that give you the right to kill me? Does it give you the right to maim me? These people who are still surviving, they've been maimed for life. And now they're in jail for 74 days. What more do they want? They can carry on their investigation. There is absolutely no, whether release of persons on bail somehow creates an encumbrance for their investigation. They can carry on the investigation. They can find out who are they have found out, apparently according to them, they have found out item number 59% after 2 months. They can carry on the investigation, but why do they need to keep us in jail? Can they return the life? They have said that one person has sustained bullet injury. There was gunfire from their end. This is reported everywhere. We have even annexed the documents, my lord. Gunfire was from their end, my lord, not from our end. And nobody has died from their end. Our people have died, my lord. And 2,000 people were there in the village, my lord, when this altercation took place. How can they attribute individual responsibility to all of these persons? They have done their part. Let them carry on the investigation, whether our detention is for the required, my lord. That is all I am submitting, my lord. If your lordship balances their case and our case, my lord, in my respectful submission, my lord, we have made out a case for bail, my lord, considering every aspect, my lord, including the length of detention. So I leave it to your lordship, my lord.
Only one point, my lord. He is time and again saying that we have killed them, we have killed them. We have not killed them, my lord. That cannot be my lord, ground, my lord, that we have killed them. One person lost their life. That cannot be a ground for the, my lord. It is the investigation will, my lord, speaks, my lord, whether they will be entitled to for bail or not, my lord. Not any sympathetic consideration.
Nobody is seeking bail on sympathy, my lord. I'm sorry, my lord.
Every time, my lord, 100 times he has said, we have
We'll
killed
see.
them. How can we return their life? That if we should return their life,
Investment was there.
that will not have any aspect on this bail petition, my lord. So these are all, my lord, cannot be a ground for, at least.
Okay. So we are pushing the
Yes. Bail parameters were.
rest of the matters will be adjourned.
Item number 58, your lordship.
Whatever, he will, she will. I have some other engagement.
Tomorrow, your lordship. 58, 85 days behind the bar, your lordship. Only one day.
In 92, did you know about it?
My lord, only one prayer
Yeah,
before your lordship rises up, my lord. In respect
58, your lordship. Item number 58, 85 days behind the bar. Kindly, tomorrow, your lordship, to your lordship.
my lord, in respect of item 40,
58 kindly consider tomorrow, your lordship. 85 days behind the bar.
Okay, she will manage and they will give us the date.
my lord, actually, item 40, I need a date, my lord, this week, my lord, because the next date is
We'll
fixed.
we'll suppose, at least, submit and give details.
Obviously.
Okay. Like the Pagano,